announcements.
Yes. Honourable members, I have an announcement to make with regard to the composition of the sessional select committees pursuant to Standing Order 69 of the Standing Orders and Rules of the National Assembly, 1995. I have to inform you that I chaired the Committee of Selection on Monday, 24th March 2025, and I have nominated the following honourable members to serve on the different sessional select committees as follows. The Public Accounts Committee. With regards to the Public Accounts Committee, Honourable Kuvalayan Kugan Parapan, Junior Minister of Social Integration, Social Security and National Solidarity, Honourable Gilbert Tony Apollon, Honourable Rameshwar Etouaria, Honourable Jean-François Francisco François, Honourable Sri Dar Jagannath, Dr. the Honourable Sandeep Prayag, Honourable Kaviraj Rukni, Honourable Mohammed Reza Shomtali, Honourable Manoj Seaburn. Furthermore, pursuant to Standing Orders 69-2A, I have appointed Honourable Adrien Charles Duval, Opposition Whip, as chairperson of the said committee. The Standing Orders Committee. With regard to the Standing Orders Committee, chaired by myself and also served by the Honourable Deputy Speaker, I have the Honourable Gavin Patrick Cyril Glover, Honourable Dhananjay Ramphal, Minister of Foreign Affairs, Regional Integration and International Trade, Honourable Georges Pierre Lejonga, Leader of the Opposition, Honourable Painevel Venkatasamy, Deputy Chief Government Whip. With regard to the House Committee, chaired by the Honourable Deputy Speaker, we've appointed Honourable Marie-Geneviève Stéphanie Anctil, Government Chief Whip, Honourable Nitish Sharma Bijan, Honourable Danielle Henriette Manon, Honourable Sridhar Jagannath, Honourable Jean-Patrice France Quirin. With regard to the Broadcasting Committee, have been appointed Honourable Patrick Gervais Asirvadan, Minister of Energy and Public Utilities, Honourable Raviraj Sinha Bichuk, Honourable Louis-Ludovic Michel Kazerne, Honourable Jacques-Edouard, Honourable Rameshwar Etouaria, Honourable Jean-Pierre France Quirin, and Honourable Manoj Seaburn. The Broadcasting Committee will be chaired by the Honourable Patrick Gervais Asirvadan, Minister of Energy and Public Utilities. The Parliamentary Gender Caucus. With regard to the Parliamentary Gender Caucus, chaired by myself, and which is also served by the Honourable Deputy Speaker as Deputy Chairperson, have been appointed Honourable Johanna Marie Béranger, Junior Minister of Environment, Solid Waste Management and Climate Change, Honourable Eileen Karen Lee Chin Fu Kun Bacha, Junior Minister of Youth and Sports, Honourable Anishta Baburam, Junior Minister of Gender, Equality and Family Welfare, Honourable Mrs. Marie-Véronique Le Govin, Junior Minister of Arts and Culture, Honourable Marie-Geneviève Stéphanie Anctil, Government Chief Whip, Honourable Adrien Charles Duval, Opposition Whip, Honourable Honourable Chetan Anand Babulal, I'm sorry, my eyes are not so good, Honourable Louis-Ludovic Michel Kazerne, Honourable Marie-Roxana Colette, Dr. the Honourable Rubna Bigam Dawiaru, Honourable Miss Danielle Henriette Manon, Honourable Roshan Jaman, Honourable Roshan Jaman, Honourable Chanda Prakash Ramkalawan, Honourable Marie Annabelle Andelana Savabati, Dr. the Honourable Babita Tanu. These, of course, have been appointed by the Selection Committee. Thank you.
Papers have been laid. Questions?
Honourable Leader of the Opposition.
Thank you, Madam Speaker. Madam Speaker, I've given notice of the following private notice question addressed to the Minister of Health and Wellness, whether in regard to Chikungunya and Dengue fever, he will state the number of registered cases thereof as a date, indicating if they are local or imported ones. B, protocols put in place at the airport and the port for the detection thereof, indicating since when. C, measures put in place for the prompt detection thereof island-wide. And 2, efficient management of reported cases thereof in government hospitals and health institutions, private clinics and private practitioners. And D, measures taken to quell the outbreak thereof and protect the public at large. Thank you, Madam Speaker.
Yes, Honourable Minister.
Madam Speaker, Chikungunya virus is an arbovirus transmitted by Aedes aegypti and Aedes albopictus mosquitoes. First identified in Tanzania in 1952, the virus has since spread to tropical and subtropical regions worldwide, causing sporadic outbreaks with significant public health and economic burdens. Dengue is also a viral infection transmitted to humans through the bite of infected mosquitoes, Aedes albopictus, which is the same vector for chikungunya transmission. While many dengue infections are asymptomatic or produce only mild illness, the virus can occasionally cause more severe cases and even deaths. Madam Speaker, a first case of chikungunya was reported on 15th of March 2025 at La Prenaise. It was a 37-year-old lady residing at La Prenaise, Tamarin. She was admitted in a private clinic as she was suffering from fever, joint pains, and had skin rashes. Appropriate treatment was given to the patient. Public health measures were immediately initiated. The patient was put on the mosquito net and provided with mosquito cream. Contact tracing exercise was carried out to identify all persons who were in close contact with the patient. 22 contacts were identified. In addition, vector control measures such as fogging, larviciding, and mist blowing were also carried out in the vicinity of the locality and the places affected persons had visited recently. An entomological survey was simultaneously carried out by the Vector Biology and Control Division of my ministry. Moreover, a multidisciplinary outbreak investigation team was set up to search for additional cases in the neighborhood. A second case was identified on 20th of March 2025. A male patient of 45 years residing at EDC, Rivière, working at Tamarin, close to the first case. The patient attended Victoria Hospital with symptoms of fever and joint pains. Subsequently, a third case was reported 21st of March 2025. A female patient residing at Royal Road, Tamarin, was suffering from fever and joint pains. On 22nd March 2025, 2 more cases were reported. A male patient of 73 years residing at Royal Road, Péribert, and another male patient of 68 years residing at Tamarin, both complaining of fever and joint pains. On 24th of March 2025, 3 new cases have been reported. As a total, we have 8 reported cases of chikungunya. I'm informed that 5 have recovered and have been discharged. The remaining 3 are stable. Madam Speaker, as regards dengue, a first case was reported on 21st of March 2025. A patient residing at Plaine Maillon and admitted at Jawaharlal Nehru Hospital. The patient was immediately put under mosquito net and given mosquito cream. A contact tracing exercise was carried out once again to identify persons who had been in close contact with the patient. 3 close contacts were identified and the exercise is still going on. Subsequently, 2 cases were identified on 22nd, 23rd and 24th of March 2025, both persons residing in the same street as at the first patient. Both patients have been admitted at Jawaharlal Nehru Hospital. Fever survey and all public health measures have been initiated by the Public Health and Food Safety Inspectorate and the Vector Biology and Control Division of my ministry. As at to date, 3 cases of dengue have been registered, out of which 1 has recovered while the 2 others are still admitted and under care. In short, Madam Speaker, with respect to Part A of the question, the number of registered cases of chikungunya and dengue fever are 8 and 3 respectively, and all these cases are local ones. As regards Part B, The following protocols have been put in place at the airport and the port since they had come into operation. All incoming passengers are screened for the following diseases at the health counter of the airport and port: avian flu, chikungunya, dengue, filariasis, malaria, plague, yellow fever, cholera, monkeypox, Ebola, Marburg, SARS, MERS, COVID-19, Zika. Data captured include name, local address, contact number, country of origin. All data are captured through the Power Business Intelligence System daily from the online digital all-in-one form or its printed version, then transmitted to respective district head officers on the same day. Health surveillance activities are conducted by both the Public Health Food Safety Inspectorate for non-vector-borne diseases and the Health Surveillance Cadre for vector-borne diseases. There are actually 97 health surveillance officers in post for the surveillance of vector-borne diseases. Health surveillance activities are carried out through physical visits where body temperature, personal data, blood sample, blood smears or blotting paper are taken and dispatched to the Central Health Laboratory. Blood samples are then sent to the laboratory for examination as soon as possible. The National Health Surveillance System has been reinforced. Number of persons put under surveillance from January to February 2025 are as follows. Surveillance, cholera surveillance 2,542, malaria surveillance 13,840, Ebola surveillance 355, Zika surveillance 8,772, and Chikungunya surveillance 3,673. Dengue surveillance 5,632, plague surveillance 6,403, SARS avian flu 6,531, other diseases 37,701. Madam Speaker, I regard Part C it is to be noted that chikungunya and dengue are notifiable diseases under Section 42 of Public Health Act 1925, which imposes mandatory requirement for notification of suspected cases by treating doctor of both private and public sectors of my ministry. In addition, as part of the ongoing surveillance, my ministry has implemented the integrated diseases surveillance and response strategy, wherein 11 priority diseases, including chikungunya and dengue, are reported to the Communicable Diseases Control Unit, which operates under the purview of my ministry. Since there was an outbreak of chikungunya in La Réunion Island, and with the influx of large number of passengers therefrom, a case definition of the disease was circulated to all doctors in the public and private sectors in Mauritius and Rodrigue. Continuous medical education was carried out in all health institutions of both private and public sectors. An operational plan was revised for the prevention and control of chikungunya, was operated and approved in February 2025 in view of the exponential increase in the number of cases in Réunion Island since the beginning of this year. The plan was reviewed with special focus on chikungunya and has been amended in view of the impending operationalization of the Public Health Emergency Operations Center to include components such as incident management system, rapid response team at both regional and national levels. The operational plan provides for strengthening of surveillance, capacity building, and risk communication, and community engagement during the inter-epidemic seasons. The operational plan has been circulated to allow for a standard approach at the management of an outbreak. Even before the detection of the first case, I wish to inform the House that on 16th January 2025, I chaired a multi-sectoral meeting on vector-borne diseases to enhance coordination among other ministries, including agro-industry, environment, tourism, local government, public utilities, amongst others. I also wish to inform the House that Vector Biology and Control Division of my ministry has conducted various mosquito surveys, and since March 17, 2025, 15 mosquito surveys around chikungunya cases and 4 surveys around dengue cases. In total, 3,006 sites were inspected, out of which 34 sites contain larvae of Albopictus. Since the beginning of this year, 918 tests have been carried out for chikungunya and dengue by Central Health Laboratory, out of which 8 cases of chikungunya and 3 cases of dengue have been confirmed. I also wish to inform that the Central Health Laboratory is adequately equipped to diagnose the chikungunya and dengue. A stock of reagents for dengue is 34,000 tests and for chikungunya 8,000 tests. The measures taken to quell and protect the public health at large. First, we're conducting intersectoral meeting chaired by me to assess the present situation. Actions are taken to foster collaborative support from governmental bodies and non-governmental organizations. Technical meetings are held daily to assess and to review the situation. At district level, the following measures prevail. Conduct of environmental health assessment in regions, localities affected within a radius of 300 meters of the case locus to detect mosquito breeding places. Perform field vector control operations which include indoor residual spraying, outdoor residual spraying, larviciding, mist blowing, fogging, conduct of entomological surveys to assess larvae and adult mosquito indices, conduct of fever surveys and contact tracing, rapid examination of blood sample by Central Health Laboratory, health education at the community level, raising of community awareness through mass media, radio, television, digital health platform, and ensuring community participation. The following has been achieved from notification of the first cases of Chikungunya and Dengue. Fever survey since 16th of March 2025 up to date. Total number of household visitors 2,045. Total number of blood sample blotting paper taken 201. Total number of contact traced 72. Notices served upon author of nuisances. Total number of notices served 25. Total number of water notices served 111. Statement on nuisance served upon local authorities as other government institutions. Total number of statement of nuisances served 62. Larviciding, total number of premises 11,543. Mist blowing, total number of premises 4,566. Fogging, total number of premises fog 3,346. Madam Speaker, the local authorities are involved in the cleaning of bare lands and also collection of bulky waste. They are also responsible for cleaning of drains as per established program of work in collaboration with the Land Drainage Authority. I'm informed that the Ministry of Local Government, that the above measures are ongoing, and following a meeting I had personally chaired on Monday, 17th of March 2025 with officers of my ministry and also representatives from the Ministry of Local Government, Ministry of Environment. I'm informed that a coordination meeting was held at the level of the Ministry of Local Government with all the 12 local authorities, National Environment Cleaning Authority, the Mauritius Facilities Management Company, and Living Environment Unit of Ministry of Environment, Solid Waste Management and Climate Change on Friday, 21st of March 2025. A dedicated team has been set up at the level of each local authority to undertake cleaning of bare lands comprising officers from the local authorities, Mauritius Facilities Management Company Limited, Field Services and Living Environment Unit. The cleaning program is being coordinated by the National Environment Cleaning Agency. The Ministry of Local Environment has also obtained financial clearance to the tune of 11 million rupees for the local authorities to embark on a bulky waste campaign across the country, and same would start as from this weekend, that is 29th of March 2025, so as to ensure that the public are at home to remove the bulky waste. Madam Speaker, it is also with regret I have to inform the House that the outgoing government has failed in its duty of protecting our citizens, as it has made a poor provisioning of funds under the budget of the Ministry of Local Government for the allocation of local authority for the cleaning of bare lands. Only 3 million rupees was made available for the 12 local authorities when it should have been 18 million rupees. With regard to bulky waste campaign, only an amount of 15 million rupees were provided instead of 30 million. This shows, Madam Speaker, I'm informed by the Ministry of Local Government that a total of 455 officers have been mobilized for the cleaning of bare lands, and it is expected that in 4 weeks we will be able to clean all bare lands found in the radius of 300 meters from residential areas. Madam Speaker, I seize this opportunity to make an appeal to the public in general to keep the premises and underdeveloped plots of land clean and tidy, as otherwise the local authorities will be cleaning the land or premises and subsequently charge owners according to under Section 61(9) of the Local Government Act 2011. Madam Speaker, allow me to take this opportunity to shed light on how previously during previous health emergencies there had been very inefficient management of public funds. Notwithstanding the scandal surrounding the procurement of molnupiravir and ventilator from PAC and Bleachers, I wish to inform the House that Mauritius has an outstanding debt of around 1 billion rupees in respect of acquisition of COVID-19 vaccine. I'll come on this issue at a later stage in Parliament. Madam Speaker, I'm also informed during the outbreak of dengue 2024, the Ministry of Health had sought and obtained collaboration of several local authorities and private sector to step up vector control measures. A significant number of employees were deployed by the Ministry of Local Government, from the Ministry of Local Government, Local Authority, Ministry of Agro-Industry, Ministry of Environment, Mauritius Facilities and Tourism Authority. Unfortunately, work has provided their services on a 24/7 basis, but to date have not been paid their dues. An outstanding amount of approximately 55 million rupees has yet to be paid to officers of my ministry and 28 million rupees for other ministries and other departments. Madam Speaker, I would also like to mention that yesterday high-powered committee was held by the Ministry of Education and attended by all top officers, including rectors and headmasters of the private secondary institutions, and they were briefed about the measures that had to be taken. I would also like to add that about 300 employees from the Ministry of Environment and Nogi facilities are actually providing services in this field. Yesterday, I had a meeting with the representative of World Health Organizations, and we had formally initiated steps to seek technical experts from the World Health Organization specifically to assist in designing the seroprevalence survey methodology and advising on risk assessment and vector control strategies and evaluating public health system readiness for arboviral epidemics. And at the same time, Madam Speaker, I would like to mention that chikungunya vaccines are currently under development with one vaccine, Ischik live attenuated chikungunya vaccine, which has recently been approved in selected jurisdiction. Our ministry is monitoring the issue, and we hope that in the near future this vaccine will be available to us. And as far as dengue vaccines are concerned, there are 2 dengue vaccines are currently in the global market. Number 1, Dengue, a live recombinant tetravalent vaccine. It is approved in several countries, but it has got limited use. And the second is Dengue, a newer tetravalent live attenuated vaccine recently approved in Europe and some parts of Asia. We are looking into the possibility of having those vaccines once they are cleared by the WHO.
Thank you, Minister. Leader of the Opposition.
Thank you, Madam Speaker. The Honourable Minister has confirmed that we have 11 cases of chikungunya and dengue in the country. Will the Honourable Minister agree that his ministry has been slow in implementing the preliminary measures, and this has resulted in an outbreak in the western part of the island?
Madam Speaker, the fastness in which I was reading the paper prepared, if it had taken time, it would have taken 2 hours almost. So I don't understand anything which is humanly possible.
I must hear the Minister. I can't hear the last one.
So I have been so fast, Madam, because there is so much to speak on the action that we have taken. And I take this opportunity of expressing my gratitude to all those workers who were involved. If we had not taken all these measures, then Mauritius would have been just like it was in COVID a few years back.
Thank you. Next question. Supplementary question.
Yes, please.
No,
the Honourable-
precising because we have lots of young people, so they understand what's going on.
Okay, thank you, Madam Speaker. The Minister in his reply has stated that there have been no imported cases. Can he explain to the House how come? Because we know that both chikungunya and dengue are not endemic to Mauritius.
Yes, Minister.
Madam Speaker, well, I'm not an expert. I have been advised by my officers and the technicians of my ministry that these are all indigenous. This means those viruses must be in the air in the country because they have tested everywhere. And I have just mentioned thousands of tests have been conducted. Up till now, we haven't got any trace of that coming from abroad. If that had been the case, definitely I would have mentioned it. And those cases which are coming from abroad, important ones, are easier to control than those which are indigenous in the country because you don't know from where it comes. And that is the reason why we had to go throughout the nook and corner of the country, and we have to do the larviciding and the spread, larviciding and other cleaning works.
Yes, do you have another one?
Yes, Madam Speaker. In his reply, the Honourable Minister confirmed that there were no proper surveillance made either at the airport and the port. That's why we have not been able to detect imported cases. Can I ask the Honourable Minister whether the body scanners monitoring temperature at the airport is working and since when? Because we know that on a daily basis we have some 10 flights coming from Reunion Island, and as at date, we have some 10,000 cases in Reunion Island
Yes,
of chikungunya.
Minister?
Madam Speaker, number one, I was very, very clear in my language, very simple. I didn't say that we have not controlled. Since the very beginning, we have taken all the action that needs to be taken.
Port and airport.
At both airport, and even in places where there have been many crowds also, there have been regular testing work has been going on, but I maintain that there hasn't been any imported cases. And secondly, as far as the airport is concerned, many times even the Prime Minister drew my attention to this, there were no outbreak of any virus, had been drawing my attention to the fact that you have to be very careful at the airport, and I can guarantee the House that all that needs to be done, all that is humanly possible has been done. Yes, earlier they had put some, I don't know what was that, some camera was put, some equipment was put by the previous government, but none of them are working today. In the afternoon, I'm going to reply a question which was asked to me. Yes.
Okay.
Yes, in his reply, the Honourable Minister made mention to an operational plan, and he stated that he had met stakeholders of government. Can I ask him whether a task force has been set up comprising not only of government bodies, but also of stakeholders in the non-health sectors?
Madam Speaker, I just mentioned that I had presided 2 meetings, and at the same time, the local government, at its own level, they are doing their best, and they are trying to rope in. They are trying to rope in the private sector. Similar is the case, I had forgotten to mention, the case with the Ministry of Tourism. I have got a paper with me where it is mentioned that the Ministry of Tourism has also made an appeal to all the private sector to come forward and to help us. So we can't say that the private sector is not being roped into. Everywhere, wherever the private sector is found, we are making an appeal to them, and they are openly supporting us. And definitely in the days to come, if the situation, I hope it won't be like that, the situation goes bad, then of course we are going to take additional measures. As at now, I can tell you that the private sector is fully on board, and particularly local government, environment, and the Ministry of Tourism, including my ministry, we are doing the work.
We had one. Will you let then Mrs. We already have one.
The Honourable Minister said that he had a meeting with his colleague Minister responsible for education. Can I ask the Honourable Minister whether his ministry has started fogging and larviciding in our educational institutions?
In many places where the need was felt, the work has already started. And if you feel, for example, in the north, there is one institutions which we have in mind, we have to go fast. We are going to do it today. So it all depends, wherever the need is felt, we are going. At one go, we cannot take up all the institutions, but we have to go step by step. But I assure the House, if anyone has got anything to say, any request to make, we are going to immediately implement whatever we have to do.
Okay, Honourable Member, yes.
Speaker, given that the health diseases such as chikungunya has devastating impact on industries such as the tourism industry, which is already hurting, will the Minister consider bold measures, like in India, to introduce genetically modified, non-reproductive mosquitoes to kill off that species of mosquitoes, porteur chikungunya, immediately?
Madam Speaker, we haven't arrived at that situation. But as you were talking about the tourism industry, I have got a paper in front of me where the Ministry of Tourism has already sent letters to all the operators in tourism sector to ensure that the premises and immediate neighborhood have to be cleared and to be kept clean at all times with a view to preventing breeding of mosquitoes. And at the same time, they have also procured additional equipments so that they can try to intensify the work that they are doing. But now it is too premature to come to that extent.
Yes.
Merci, Madame la Présidente. Est-ce que le ministre a émis des directives claires aux cliniques privées et à cet effet? Et qu'est-ce qui est prévu si ces mesures ne sont pas respectées? Merci.
You know, according to our existing legislations, The private clinics, they are bound by the decision taken by the government. And my officers, the important officers, that is the responsible officers, are monitoring the situation, and repeatedly we are inquiring from the different private clinics as to the step that they have taken in order to help patients who are getting admitted there.
Yes, Mr. François, then Dr. Omir. But, okay, I think we can make it.
Thank you, Madam Speaker. Madam Speaker, following the detected 11 cases in Mauritius, this makes Mauritius as well already vulnerable for an outbreak at any time. Being given that the Regional Assembly have only administration for health, may I ask the Honourable Minister whether, first, he is aware of any recent reported or suspected case from Mauritius, and secondly, whether the Ministry has also activated strict control measures together with local authorities in Mauritius for people traveling to Mauritius from Mauritius, as at times on the plane, health cards are not being distributed. And if you allow me, whether he will request Regional Assembly for a foreign...
You can't answer 5 questions. One question.
I'm trying to put all in one.
Please, let him answer the first question.
Now, Madam Speaker, sir, I would like to add up one thing, because I'm informed by my officers that sterile mosquitoes are being developed and released in the atmosphere. As far as this question is concerned, of course, Roderick forms part and parcel of our country, our republic, and whatever is being done in Mauritius, definitely it will be implemented the same in Roderick. I can assure the Honourable. And at the same time, I'm sending a few officers to Roderick for that purpose.
Well, second question. Come on.
I was going to ask whether he will request Regional Assembly for ref sensitization and awareness campaigns for mass media and community at large to quell any outbreak at any time.
I look into it.
Yes, Dr. Omir.
Thank you, Madam Speaker. With regard to detection of chikungunya in the private sector and private health institutions, currently only rapid antigen testing is being carried, and subsequently they are then referred to the central lab. May I ask the Honourable Minister whether he could extend the facilities of PCR testing within private institutions so that we have a real value of the number of positive cases in the country? Thank you.
The answer is in the positive.
Okay. Okay, yes, Honourable Leader of the Opposition.
Thank you, Madam Speaker. May I ask the Honourable Minister whether patients suffering from chikungunya are being treated in the same ward as other patients, or is there a separate wards for those patients?
You know, those patients who are admitted in the hospitals, they are kept a bit separately from the other patients.
It's catching.
They are detached from the other patients.
Yes, naturally. You have one more? Yes, okay. Not much time left.
Specific to senior and vulnerable citizens, can I know what are the measures being envisaged to protect our citizens from an outbreak of that chikungunya in the country?
Madam Speaker, all the measures that I have just enunciated, these are the measures that we are taking everywhere. But in fact, for those old age, then special attempt will be made. Well, through propaganda, through television, through radio, we are trying to communicate with everybody. And I'll see to it that in all the healthcare institutions where normally they come for consultations, they will be looked into properly.
Last question.
Thank you. Madam Speaker, now that the Minister is aware of sterile mosquitoes, may we know how many mosquitoes have been released under the program since the outbreak to date?
Madam Speaker, sir, it is difficult to count mosquitoes. I'm very sorry to say I can't count mosquitoes.
Of course, I didn't hear what the Minister said. I'm sorry, Minister. Maybe it was recorded, but I didn't hear you. Please.
It's difficult for me or my ministry to count the number of mosquitoes that have been released.
Time is up. Time is up. Time is up. Yes, so now, Honourable Jaman.
Thank you, Madam. Question B197, please.
Madam Speaker, in the government program under the subtitle Restoring Integrity in the Gaming Industry, we have undertaken to restore public confidence in the gambling regulatory authority, particularly in regard to its oversight on the horse racing industry. Relevant amendments will be brought to the Act to ensure that the GRA operates as a trustworthy regulator in the gaming and betting industry in a transparent and accountable manner. Madam Speaker, the Gambling Regulatory Act of 2007 has inter alia the following objectives: promoting public confidence in the integrity of horse racing industry by ensuring proper standards of conduct and competence, ensuring that gambling is conducted in a fair and transparent manner, fostering responsible gambling in order to minimize harm caused by gambling, and promoting the welfare and leisure of race-going public. It is worth reminding the House, Madam Speaker, that under the last regime, the GRA, instead of furthering its objectives, this is why I spelled them out in the Act, developed an incestuous relationship with some in the gambling world. The GRA became a den of notorious agents at the service of the political masters. From 2015 to 2024, the GRA totally destroyed public confidence in the gaming industry and the horse racing industry. In fact, it literally decimated horse racing in Mauritius. It acted more as a gambling promoting authority, dishing out various licenses in every nook and corner of the country. That is how the then government, if you remember, said they want, in 2015, said they want to prevent Mauritius becoming a nation jugadera. This is precisely what they did. Regarding part A of the question, I'm informed by the Gaming Regulatory Authority that a total number of 186 licenses has been issued. I'm
sorry.
But it was a mosquito.
It was
I repeat, Madam Speaker.
I'm sorry, Prime Minister, it's the equipment.
Yeah, I'm sure. Like everything else in this country, everything is falling apart. I'm informed, Madam Speaker, that the Gambling Regulatory Authority, as I said, that a total number of 186 licenses have been issued to SMS Porias Limited from 2015 to November 2024. And they are as follows: 25 bookmaker licenses for conducting fixed odds betting through remote communications by SMS. 20 bookmaker licenses for conducting fixed odds betting on football matches taking place outside Mauritius. 141 limited payout machine licenses. With regard to Part B of the question, Madam Speaker, I'm tabling a list of the names of the current shareholder and directors of SMS Parias Limited, obtained from the Gambling Regulatory Authority. According to this list, Mr. JMLS is neither a shareholder nor a director of SMS Parias Limited. I am, however, informed by the GRA that Mr. JMLS was a shareholder of SMS Parias Limited from the 22nd of April 2009 to 23rd of May 2014. He was also a director of SMS Parias Limited from the 15th of January 2008 to 17th April 2009 and from 10th of January 2013 to 18th of March 2013. According to records of the Corporate and Business Registration Department, there has been successive transfers of shares from Mr. JMLS to a list of persons and eventually in 2014 to Mr. PT. I'm not saying the full name. I'm informed by the GR that at the time of application of his personal management license, Mr. JMLS submitted a copy of the registered power of attorney in favor of Mr. PT, who is the sole shareholder of SMS Parias Limited at the time, and gave him power of attorney to generally act on his behalf to manage, conduct, carry on, and administer all his affairs and properties in Mauritius and to represent and act for him in all matters. It is clear, Madam Speaker, it appears at least, that it could be a case of prête-nom, and this is being looked into.
Thank you. Yes.
Thank you, Prime Minister. Madam Speaker, given that there are other betting shops, I will mention a few: Busco, Silver Sports, Easy Win, Value Plus, PLS, Top Pool, Footy, Better 9 and Book System. All these are currently operating under the same umbrella, but sous des différents prête-noms. In order to shed light on all these issues and in public interest, can the Honourable Prime Minister undertake to establish a full-fledged inquiry in order to inquire on the empire of JMLS? Thank you.
Yes, I could, but I must say, on 20th of March, 2025, SMS Parias Limited has lodged a case at the Supreme Court against the GRA.
Okay. All right. Yes, Honourable Third Member for Beaubassin-Petite-Rivière.
198.
Madam Speaker, I wish to inform the House that on the 27th of February 2015, Cabinet had agreed to the signing of an MOU with the Government of India for the improvement of sea and air transportation facilities at Agaliga. I wish to inform the House that this MOU was signed on the 11th of March 2015. Subsequently, following a PNQ on the 31st of March 2015, a copy of the MOU was tabled in the House. Madam Speaker, the agreement with the Government of India on infrastructural projects in Agaliga was signed on the 27th of May of 2017. It relates to the protection and safeguarding of our maritime security needs in the following areas. Among others, first, a surveillance and monitoring of our vast EEZ, which is of 2.3 million square kilometers. Second, counter-piracy, counter-terrorism, counter-narcotics, and human trafficking. Third, controlling poaching and illegal, unreported, and unregulated fishing. 4, provision of hydrographic services. 5, promoting of economic development, including blue economy initiatives. 6, emergency response, including search and rescue. 7, marine protection response. And 8, humanitarian assistance and disaster relief activities. Madam Speaker, the new airstrip, the jetty, and the associated infrastructure have been entirely financed and constructed by the Government of India. The agreement provides that the title to all the immovable property being constructed in Agaliga by the Government of India will remain with the Government of Mauritius. In addition, the Government of India is also assisting the Government of Mauritius in the operation and maintenance of the facilities, and the relating costs are being borne by the Government of India. Accordingly, technical experts from the Government of India are currently operating and maintaining the facilities. With regard to Part A of the question, I would like to inform the House that the airstrip and associated facilities that have been constructed in Agaliga include a 3-kilometer long and 45-meter wide airstrip. It also includes an air traffic control tower, a passenger terminal building, an aircraft hangar, and an electrical station, as well as a new jetty. With regards to Part B, C, and D of the question, there is a confidentiality clause in the agreement, similar to other agreements that Mauritius has signed with other states. We are bound by this confidentiality clause. However, I can assure the House that the Honourable Member, that the Deputy Prime Minister and myself have looked at the agreement, and we can state that there is nothing that should be a matter of concern, especially in respect of the sacrosanct principles of sovereignty and territorial integrity.
Thank you. Yes, Mr. Pierre.
Merci, Madame la Présidente. Dois-je rappeler à la Chambre que l'actuel Deputy Prime Minister, de même que l'honorable Boulel, lors de ses précédents PMQ, alors qu'il était leader de l'opposition en 2022, le 26 juillet et octobre 2023, les deux, avec raison, avaient réclamé que tout soit rendu public, qu'il n'y ait pas de clause confidentielle, comme le précédent gouvernement s'était, je ne dirais pas caché, mais n'avait pas voulu à l'époque aussi rendre public cette clause confidentielle. Donc, doit-on comprendre que, malgré que l'actuel député Prime Minister, l'honorable Boulel, alors qu'il était leader de l'opposition, qu'est-ce qui peut empêcher le Premier ministre aujourd'hui de dévoiler à la Chambre, puisqu'il y a, comme il vient de l'affirmer, il n'y a rien de compromettant dans cet accord. Qu'est-ce qui l'empêche de rendre public justement cet accord entre l'Inde et Maurice?
Yeah, not only the Deputy Prime Minister and Minister Boulel, I also said that during the campaign. But the agreement, there is a clause of confidentiality. We didn't see the agreement at the time. There is a clause. That agreement subsumed the understanding reached in 2015 of the Memorandum of Understanding. That is the reason.
You have another question?
J'ai une autre question, Madame la Présidente, avec votre permission. Plusieurs médias étrangers, dont certains journaux renommés, réputés de l'Inde, avaient...
In this house, we're not going to talk about the media. We want to know what is your question.
Ma question est la suivante. Il y a une question que toute la population se pose, et même
Ça, c'est bien.
ceux qui sont concernés par ce qui se passe à Galega. Ils veulent savoir, est-ce que cette base, est-ce qu'à Galega, il n'y aurait pas une base militaire? Est-ce qu'à Galega ne serait pas utilisée à l'avenir comme une base militaire?
À l'avenir, OK.
I can assure the House it's absolutely not the case.
All right? Yes. Honourable third member for Flatten Bonacay.
Madam Speaker, B199.
Madam Speaker, I'm informed by the Commissioner of Police that the Police Family Protection Unit was set up in September of 1994 to attend to cases of domestic violence, child abuse, and child beyond control. However, over the years, with an increase in the number of cases of child abuse, another unit, the Brigade pour la Protection des Mineurs, was set up in May 2004 to deal particularly with cases of child abuse and juvenile delinquency. Both units were operating under the aegis of the Central Criminal Investigation Department. With the promulgation of the Children's Act, the Child Sex Offender Register Act, and the Children's Court Act in the year 2020, the Child Protection Act of 1994 and the Juvenile Offenders Act of 1935 have been repealed. Consequently, the role and responsibilities of the Police Family Protection Unit and the Brigade pour la Protection des Mineurs were replaced by a new unit under the appellation of Brigade pour la Protection de la Famille in January of 2022 in order to implement the provisions under the foregoing legislations. However, the Brigade pour la Protection de la Famille was assigned new responsibilities to include the implementation of the recommendations of the National Strategy and Action Plan of 2020 to 2024 on the elimination of gender-based violence and to work with other relevant stakeholders such as the Ombudsperson for Children's Office of the Director of Public Prosecutions, and the Ministry of Gender Equality and Family Welfare, among others. To ensure effective service delivery, 10 subunits of the Brigade pour la Protection de la Famille have been set up by the police in strategic locations throughout the island, including Rodrigues. Madam Speaker, with regard to Part A1 of the question, I'm informed by the Commissioner of Police that since the inception of the Brigade pour la Protection de la Famille in January 2022, cases of child abuse are being addressed in a professional manner and there is proper coordination among the various stakeholders. The staff are given adequate local and overseas training to handle such cases and to fine-tune their cognitive, interviewing and investigating skills to be able to interview and record statements from victims. They have adopted a victim-centered approach to prevent secondary victimization and stigmatization. Concerning juvenile delinquency, such cases are dealt in two ways according to Section 41 of the Children's Act of 2020. First, the police or their aggrieved parents may apply to the Mauritius probation and aftercare services for a parenting support intervention in order to assist the parents in performing the parental duties with respect to the management of the child's behavior. Thereafter, for this purpose, the probation officers make an assessment of the child's behavior, and if the outcome of the assessment is favorable, a report is submitted to the police. And second, if the outcome of the assessment is unfavorable, the report is submitted to the Protection Division of the Children's Court for the issue of a preventive intervention order by the magistrate, which may include, among others, placement in an institution in accordance with the Probation of Offenders Act, attending drug or alcohol treatment or mental health counseling plan, participating in group activities, including counseling and complying with such order as the magistrate may determine. As regards Part A2 of the question, it is envisaged to reinforce the strength of the Brigade pour la protection de la famille with additional resources to enable this unit to further meet the growing demands for their services. Neighborhood officers at police stations will be encouraged to act as family liaison officer for profiling and identifying children with deviant behaviors and for referring them to the relevant agencies for follow-up and counseling. During sensitization campaign, members of the public will be encouraged to tip off the police of suspected cases of child abuse and child exhibiting antisocial behavior for remedial actions. Regards Part B of the question, in view of the increasing number of complaints being received concerning the follow-up of children beyond control and domestic violence cases, the whole system is being reviewed.
Thank you. Yes. The Honourable Fourth Member for Port Louis North.
Yes, B200.
Yes.
Madam Speaker, the Police de l'Environnement is established under Section 14 of the Environment Act of 2024 to provide for the Director of Environment such assistance as may be required in order to enforce the environmental law. The duties and responsibilities of the Police de l'Environnement include the enforcement of environment-related legislations and pollution prevention, sensitization on environmental issues, investigation into breach of environmental laws and attending to public complaints on such matters. On the 1st of October 2022, the following two regulations on environment protection relating to noise pollution were promulgated. One, the Environment Protection Regulations of 2022, environmental standards for noise, that is, which provide for three categories of noise and their respective permissible level, namely industrial, neighborhood, and power station. The primary sources of noise nuisances, including playing of loud music, machinery used in workshops, nightclubs, and entertainment centers operating at night, particularly those located in densely populated residential areas. And two, Environment Protection Control of Noise Regulations of 2022, which entirely enhance enforcement and facilitate prompt action and reduce lengthy legal procedures. A fixed penalty system with a fine of 10,000 rupees was introduced for that offense of noise pollution constituting a nuisance. Madam Speaker, in addition to its main office in Port Louis, the Police de l'Environnement has been decentralized in 7 divisions across the island to enhance the operational effectiveness and efficiency to ensure that they work closely with the community in the role to protect the environment. It also operates a hotline to receive complaints. The unit also carries out night patrols to monitor noise and disturbances around places of entertainment, as I said, such as nightclubs, restaurants, pubs, private clubs, and bungalows. Presently, the Police de l'Environnement is manned by 37 police officers who are deployed in 7 teams and has 8 vehicles to cover the whole island. The number of contraventions for the offense of causing noise, constituting a nuisance, has increased significantly, from 52 in 2021 to 138 in 2024. Since the beginning of this year to date, 60 such contraventions have been established by the Police de l'Environnement. Since the number of cases is clearly on the rise, the police is considering strengthening its resources to better educate the public through awareness campaigns and for greater intervention on the ground.
Thank you. Your next question? No.
Supplementary.
You want to supplement?
Yes. Madam Speaker, the Prime Minister will agree that 4 officers spread along 3 shifts, police shifts, so at any one shift, during one shift, 1 police officer is not nearly enough especially in regions like in the north, you have around 12 public beaches, plus nightclubs, restaurants, etc., etc. Therefore, will he consider, firstly, like the question asked, reinforcing the ranks of the police de l'environnement significantly so that it can work as is expected?
Madam Speaker, I've just said that.
Second question, Madam Speaker. Pending the reinforcement to occur, will the Prime Minister ensure that no more police stations are equipped with noise detectors so that they may enforce the laws without having to wait for the police de l'environnement, for example, to issue a contravention subject to having a noise detection emittance to ascertain that the person is in contravention? Will he consider equipping those police stations immediately pending the reinforcements?
Something we could consider, but the police de l'environnement already have the equipment.
Yes, Madam Speaker.
Yes, I understood the question.
If I may, Madam Speaker, we've established there's only one per shift. So therefore, pending that it is reinforced, a simple solution now would be to equip the police
Don't
station.
tell the Prime Minister what to do. Ask him a question.
But that is the question, whether he will consider.
Prime Minister, would you like to
I
elaborate?
can't say I understood the question. I thought I already answered it, but say it again.
Yes, thank you.
Let me rephrase. The question, Prime Minister, that I think I understand is can we give these, this type of equipment to police stations, not to police of environment?
But then,
Is that the question?
I'm not sure that.
Pending that, clearly they are understaffed, pending a reinforcement at the level of the police de l'environnement, and given the number of cases on the rise, will the Prime Minister, it's an easy fix, ensure that police stations, normal police stations, are equipped with noise detectors so that they can enforce the law?
That's what I just said.
It is for the police de l'environnement to go and check. It's not for the
Honourable Gentleman.
police officers in the station that go and check. It's the police de l'environnement.
Let's get your next question. Shh. Let's get your next question.
Madam Speaker, I'm informed by the Commissioner of Police that crackdown on motorcyclists riding without helmets or motorcycles with modified loud exhaust or without license plates on public roads are being conducted regularly. These operations involve the deployment of the traffic branch, local police, emergency response services, the divisional support unit. The teams are reinforced by the SMF and the special support unit whenever required. An average of 300 crackdown operations are conducted monthly, island-wise, against motorcyclists. I'm also informed, Madam Speaker, by the Commissioner of Police that a three-pronged strategy comprising enforcement, education, and multi-sector partnership have been put in place to address road safety issues. These include conducting targeted, visible, and covert operations at road accident hotspots, setting up a road safety watch schemes in collaboration with the local community to identify probable black spots and instances of reckless driving, conducting crackdown operations with involvement of various units of the police force, performing SNAP, alcohol test and drug test operations, and carrying out sensitization campaigns on road safety through face-to-face forums, mainstream media, and social media. Madam Speaker, the crackdown operations and the three-pronged strategy deployed by the police are yielding results. From January 2024 to March 2025, a total of 9,142 crackdown operations were conducted, including 4,218 specifically targeting motorcycles. During these operations, the following contraventions were established: 1,431 for riding without helmets, 1,541 for riding motorcycles with loud exhaust, 4,622 for riding motorcycles without license plates. The situation is being carefully monitored, and if need be, legislation will be revised to impose higher penalties on offenders.
Yes, I have. I've only got 5 minutes left. If you ask one or two questions, nobody else will be able to speak.
Well, thank you. Madam Speaker, the Prime Minister, the figures given are concerning. Thousands of contraventions. However, the problem persists. Will the Prime Minister consider the use of safe city cameras to pinpoint the areas where there are recurrences. I can tell the Prime Minister, many areas close to where I live myself, where there are recurring, Sir.
Question. You can do that
where certain,
privately.
where motorcyclists are using their motorcycles without helmet, without number plates, loud exhaust, and the police is not effectively cracking down on that.
So your
The question
is
is whether he will use the safe city cameras to ensure that the police are in fact being efficient and not just rely on what the
that is
local
enough.
stations are
That
saying.
is enough. Safe city cameras.
In fact, Madam Speaker, the safe city cameras are not now being used to spy on people, but in fact to see things like this, and they are being used for that.
Okay, next question. Honourable First Member for La Caverne and Phoenix.
Thank you, Madam Speaker. B202, please.
Madam Speaker, in regards to part A of the question, I'm informed by the Acting Director General of the Mauritius Ports Authority that as at date there are 27 idle fishing vessels lying in the port for more than 1 year. With regard to part B of the question, idle vessels do not have certificate of seaworthiness and insurance cover and accordingly pose serious environmental risks, navigational and fire hazards as well as security threats. To discourage the long stay of fishing vessels, on the 16th of January of this year, the Mauritius Ports Authority has, under Section 32(5) of the Ports Act, directed the owners, the agents or representatives of the 19 fishing vessels to take reasonable steps to remove the vessels and to settle all accrued port charges within 15 days. 7 fishing vessels are subject to an inquiry by the Financial Crimes Commission for asset recovery. The remaining 1 fishing vessel is a matter of foreign arbitration proceedings. The advice of the Attorney-General's office is being solicited by the Mauritius Ports Authority to proceed with the disposal of these idle vessels in accordance with the provision of the Ports Act. I'm informed by the Acting Director General of the Mauritius Ports Authority that an amount of 4 million rupees representing parking fees due by the owners of the 27 idle vessels is still outstanding. In addition, an amount of 227,295 has been incurred by the Mauritius Port Authority in terms of publication of notices. In cases the vessels cannot be sold, an amount of 5 million per vessel will have to be borne by the Mauritius Ports Authority for the disposal by demolition facilities. Madam Speaker, the Mauritius Ports Authority is working closely with the Ministry of Agro-Industry, Food Security, Blue Economy and Fisheries to ensure that the measures are put in place to deter the presence of idle fishing vessels in the port.
Thank you. Yes? That is okay? Yes? We got 2 minutes left. Honourable Fourth Member?
Yes.
2 minutes.
Thank you. B203.
Madam Speaker, in regard to part A of the question, I'm informed by the Commissioner of Police that as from 11th of November 2024 to 24th of March 2025, 31 cases have been reported to the police which relate to incidents on members of the public on public beaches. Of these, 22 resulted in physical injury, including 1 case of an ill treatment of a child and 1 case of death, and 9 related sexual abuse cases, out of which 8 involved minors. I'm also informed that 15 persons have been provisionally charged and the inquiries are ongoing. With regard to part A of the question, I'm informed by the Commissioner of Police that in order to maintain law and order on public beaches, the police is implementing the following measures. Visible police presence through regular foot and bike and vehicle patrols by the regular police, as well as other specialized units, namely the Emergency Response Services, the National Coast Guard, the Police du Tourisme, Central Investigation Department, and Anti-Drug and Smuggling Unit, particularly during weekends, public holidays, and busy hours on the beach. 2 surveillance through, again, safe city cameras were available with constant monitoring at the police main command and control center. Public awareness campaigns by officers of the National Coast Guard, Police du Tourisme, and regular police to educate beachgoers, including tourists, on safety measures and reporting mechanisms. And fourthly, close collaboration with local authorities and other stakeholders, such as the Beach Authority, to enhance response and security of beachgoers. Madam Speaker, moreover, with a view to increasing surveillance along coastal regions, especially during the night, police presence is enhanced along these regions, whereby various teams, including the traffic unit, the SMF, Special Mobile Force, the Special Support Unit, and the local police conduct roadblocks, visible checkpoints, and targeted drug test operations.
Thank you. Time is up. Time is up. No question. Time is up. Members, the table has been advised that the following PQs have been withdrawn: B207, B209, B211, B208, and B10. 210. I'm sorry, B210. Now I call on Honourable Second Member for my Beauplain Magnan.
Thank you, Madam Speaker. B213.
Okay.
Thank you very much. Madam Speaker, the question is where matters stand. Matters are still at a standstill, but we'll address them forcefully to ensure that the process is reversed. This is a problem which is acute and chronic, and there are many stories to be told, and there are many stories which remain untold. Let me remind our friend that this issue of relocating pig farm at Kawa-Acacia and Le Bouchon was raised in the House in July 2016 through Parliamentary Question B/475, addressed to the then Minister of Agro-Industry and Food Security by Honourable British Ramphal. In fact, I also raised the matter at Adjournment time. Now, at that time, it was stated that a potential site would be identified in the south within the next few months. Despite 10 years in power, the previous government failed to implement concrete measures, offering only empty promises. Nevertheless, members of the House should rest assured that the Food and Agricultural Research and Extension Institute and Rosebell Sugar State have already been requested to identify a suitable site for the relocation of pig farm at Kawa-Acacia and Le Bouchon. But this is a one-off solution being undertaken given the exceptional circumstances. And all action will be guided by the need to uphold public health and sustainable agricultural practices, ensuring that any solution for the pig rearing industry remains practical and compliant. We even have to seek the views of wastewater authorities, CWA, and there's a call also for a preliminary environment review. So this is an issue that cannot be treated lightly. This is the reason as to why a committee has been set up at the level of my ministry with relevant stakeholders to look into the issues which I have raised relating to pig breeding around the island in a holistic manner. And we're going to hold a meeting with all the stakeholders on Thursday, the 27th. Thank you.
Thank you. Yes.
Thank you, Mr. As the Minister is aware that there is a serious risk to water pollution, and as I can show you some pictures just taken near the rivers.
Nobody can see that.
Okay, especially in case of heavy rain, pig segregation can discharge in neighbored rivers. Whether we will find an appropriate place to relocate these pig farmers, and if he intend to meet both inhabitant and the owner of the said farm.
You can communicate to the Minister the document. Yes, Minister.
It's one way of communication.
No, but comme ça.
It has prime time also on television, and it's right for the constituents. Now, as I've stated, this is a problem which needs to be addressed forcefully in a meaningful and effective manner. Hence, the relevance of this committee which is going to be set up, because there are many other issues. I've raised the problem of contamination of underground water, and this is an issue that has to be treated with all the finesse and delicacy it entails. Okay?
Yes. Honourable Etoiria, yes. Honourable
Madame la Présidente, merci. La question B214, s'il vous plaît.
Madame la Présidente,
Oui.
Avec votre permission, je répondrai ensemble aux questions parlementaires B214 et B244, car elles portent sur des sujets similaires. Madame la Présidente, j'ai été informé que la Central Electricity Board a attribué le contrat pour 2 centrales hybrides d'énergie renouvelable à IHF de 30 MW en 2022 à Correct Solar International Mauritius Limited, à l'issue d'un appel d'offres international. Le 15 février 2023, Correct Solar a signé 2 contrats d'achat d'électricité avec le CEB concernant les 2 projets AEHF, à savoir Bellevue 2 et Bellevue 3. Madame la Présidente, j'ai été informé par le CEB que les 2 sociétés, Bellevue 2 et Bellevue 3, n'ont pas rempli les conditions préalables spécifiées dans leurs PPA respectifs, à savoir l'obtention de tous les permis applicables, la sécurisation des accords fonciers et de servitudes de passage et la finalisation des accords de financement. Bellevue 2 a obtenu son certificat IDB le 23 décembre 2024 et a demandé sa licence IAE le 23 août 2024. Concernant Bellevue 3, la Road Development Authority, ADA, prévoit une déviation qui traversera le site du projet. Le 10 mars 2025, Bellevue 3 a soumis son plan d'implémentation à la ADA pour approbation. Bellevue 3 n'a pas encore son certificat IDB. Madame la Présidente, en ce qui concerne la partie B du PQ 244, je suis informé par le CEB qu'un montant total de 58,68 millions de roupies a été payé par le promoteur à la CEB à titre de dommages et intérêts pour retard pour Bellevue 2 et Bellevue 3. Il convient de rappeler que ces 2 projets, Madame la Présidente, ont récemment suscité des vives controverses en raison de plusieurs changements d'emplacement. À ce jour, ils n'ont toujours pas été concrétisés et, comme je l'ai indiqué, un autre problème foncier est apparu pour Bellevue 3. Madame la Présidente, des doutes légitimes subsistent quant aux conditions dans lesquelles le contrat a été attribué à Correct Solar, notamment en raison du changement successif de site après l'allocation du projet. À l'origine, Correct Solar avait proposé un site situé sur un terrain du groupe Terra dans le nord du pays. Par la suite, l'entreprise a proposé un site à Baie du Tombeau pour finalement opter pour Mar d'Australia. Ce changement, à plusieurs reprises du site initialement retenu, soulève des interrogations légitimes sur le respect des conditions du contrat. De plus, 2 avis légaux successifs émanant du même cabinet juridique sont venus semer le doute. Le premier avis concluait que le changement du site n'était pas conforme aux exigences du contrat, du PPA, de Power Purchase Agreement, tandis que le second affirmait le contraire. Cette contradiction ne fait que renforcer la nécessité d'un examen approfondi de l'attribution de ce projet. Madame la Présidente, ma lecture de ce projet est claire. Le site initialement proposé faisait partie des conditions essentielles du contrat. Et toute modification ultérieure aurait dû être réglementée par un cadre légal sans ambiguïté. Un autre élément préoccupant concerne les permis nécessaires au projet, que Correct Solar n'a pas obtenu dans les délais impartis. En conséquence, l'entreprise a pris du retard dans la réalisation du projet, ce qui a impacté sur la planification énergétique du CEB. Le CEB comptait sur une production de 60 MW de ce projet pour son mix énergétique. Or, face à ces retards, le CEB ne peut pas attendre indéfiniment et il est donc contraint d'examiner d'autres alternatives pour garantir un approvisionnement énergétique stable. Face aux nombreuses irrégularités potentielles relevées, j'ai décidé de solliciter l'avis légal du State Law Office afin de déterminer si les implications juridiques entourant l'attribution de ce contrat, ce correct cela, ont été respectées. Cette démarche vise à clarifier plusieurs points essentiels. D'abord, tous les compétiteurs ont-ils bénéficié du même traitement lors de l'appel d'offres? Les clauses du Power Purchase Agreement, le fameux PPA, ont-elles été scrupuleusement respectées? Les avis légaux contradictoires peuvent-ils être justifiés? Et en dernier lieu, pour quelles raisons et dans quel cadre le CEB a-t-elle sollicité 2 avis légaux?
Okay. Yes, honourable member.
Madame la Présidente, puisque le ministre a déjà dit qu'il y avait beaucoup de controverses autour de ce contrat, est-ce que le ministre a-t-il une idée pourquoi le CEB est en train de s'obstiner à aller de l'avant avec ce contrat? Et je comprends maintenant que le ministre va chercher un avis du State Law Office, mais je ne comprends pas pourquoi le CEB est en train de s'obstiner à vouloir aller de l'avant avec le contrat.
Short and sweet.
Comment?
Short and sweet.
Oui, Madame la Présidente, j'ai énuméré les zones d'ombre et j'ai donné aussi ma lecture de la situation. Je ne suis pas de formation légale. Je dirais que nous avons pris la décision de référer ce cas au State Law Office, à la lumière. Je peux promettre à l'honorable qu'à la lumière des avis qu'on aura, les advices qu'on aura du State Law Office, le gouvernement prendra une décision très rapidement.
Yes.
Madame la Présidente, est-ce que le ministre est-il au courant des négociations en cours, qui seraient en cours pour la reprise de l'entreprise Correct Solar par des investisseurs étrangers?
Êtes-vous au courant, monsieur?
Non, je ne suis pas au courant, Madame la Présidente.
Pas au courant. Next question. Honourable second member for Grand Bay Poudre d'Or.
Thank you, Madam Speaker. B215.
Madam Speaker, I'm informed that the Goodlands Mediclinic started its operations in October 2014 and offers comprehensive healthcare services to meet the community's needs. It serves a population of approximately 25,500 people. The clinic provides medical services to patients from several localities, namely Goodlands, Bois-Rouge, Madamazo, Mapu, L'Ecclesio, Mamzelzan, Petit Village, Roster, Saint-Antoine, and Triangle. Madam Speaker, concerning party of the question, the Goodlands Mediclinic operates 7 days a week from 8 a.m. in the morning to 9 p.m. daily, including public holidays. The pharmacy services also operate from 8 a.m. in the morning to 9 p.m. on a daily basis. Madam Speaker, with regard to part B of the question, the Mediclinic provides a wide range of facilities and services, including general consultation for common illnesses, specialist consultations in fields such as internal medicine, gynecology, cardiology, and pediatrics, and a dedicated non-communicable diseases unit. The non-communicable diseases unit offers vital services like diabetes management, diabetic retinopathy screening, nutritionist services, and tobacco cessation programs. The services include maternal and child care, dental consultation, family planning, vaccination programs, and community health rehabilitation. Madam Speaker, the Mediclinic also provides specialized diagnostic and treatment services such as X-ray imaging, ECG, ultrasonography, and rapid testing for HIV, COVID-19, and dengue. A fully equipped pharmacy ensures the dispensing of methadone and essential medications. The Mediclinic also caters for specialized care such as diabetic food care and family planning counseling to meet specific patient needs. Madam Speaker, as regards part C of the question, the staffing of the Mediclinic comprises 49 staff members, including 14 medical professionals, 20 nursing staff, 11 supporting staff, and 4 general workers, all working together to provide healthcare services to the community.
Yes, one.
Will the Minister confirm whether the Goodlands Mediclinic X-ray department will operate in the afternoon until it is closed to accommodate patients and what measures will be put in place to extend the services?
Madam Speaker, already we have got about 49 staff members here, and we have an acute shortage of technicians in that field. But nevertheless, I'll convey your request to the responsible officers of my ministry.
Thank you, Minister. Honourable Third Member for Port Louis Central.
B216, please.
Madam Speaker, I'm informed by State Trading Corporation that in April 2020, the then General Manager of the corporation was requested by Permanent Secretary of the Ministry of Commerce and Consumer Protection to initiate action for payment of 11 units of body temperature measurement thermal camera solution procured from both Digital Company Limited for the total amount of 6,600,000 exclusive of VAT. The Board of State Trading Corporation approved the payment of the invoices on 3rd April 2020, and payment was effected by the State Trading Corporation as follows. On 3rd April 2020, an amount of 690,000 for one thermal camera. On 6th April 2020, an amount of 4,200,000 representing 70% of total invoice amount of 6 million rupees for 10 units of thermal camera. The remaining 30% amounting to 1,800,000 was paid on 25th November 2020. The State Trading Corporation has also informed that upon instruction from the National Task Force Committee COVID-19 chaired by the then Prime Minister, one thermal camera was installed at the entrance of the Prime Minister's Office for Security Control of Visitors and Guests, whereas the other 10 units were delivered to my ministry in hospitals and clinics. Madam Speaker, as regards part B of the question, I'm informed that all the thermal cameras were put to use and were installed as follows. Health Region number 1, one unit was delivered at Dr. A.G. Jitu Hospital and one at the Subramaniam Bharati Eye Hospital at Mocha. Both are out of use. The one at Dr. Jitu Hospital since 2023 and the one at Mocha since 2022, and both units are faulty. Health Region 2, one unit was provided at SSRN Hospital and the same is out of use since 2022 and not in working condition. Health Region number 3, one unit was delivered to Dr. Bruno Chong Hospital. However, the unit is not being used following the relocation of services from Dr. Bruno Chong Hospital to the new Flag Hospital. Health Region number 4, 3 units were installed, namely at Jawaharlal Nehru Hospital, New Suyak Hospital, and L'Escalier Mediclinic. The one at Suyak Hospital is out of order since 2022. The other 2 units are in good working order but not in use actually. Health Region 5, 1 unit of thermal camera was installed at the entrance of Accident and Emergency Department of Victoria Hospital. The thermal camera is in good working condition but actually not in use. Emmanuel Angchil Building, I am also informed that 1 unit was placed at the ground floor of Emmanuel Angchil Building, former headquarters office of the Ministry of Health and Wellness, and it was operational at that time. Parliament of Mauritius, I am informed by Ministry of Commerce and Consumer Protection that 1 unit was placed at National Assembly and it is in good working condition and is fully operational. Madam Speaker, I am requesting the Acting Senior Chief Executive of my ministry to carry out an inquiry into the matter to find out any shortcomings and any measures to be taken so that the thermal cameras may be operational again, particularly at a time when there is a threat of outbreak of chikungunya.
Yes, one question.
Thank you. 6.6 million has been disbursed for the purchase of thermal cameras, and we've heard that so many of them are either not in working conditions.
Please.
May I ask the Honourable Minister whether these equipment were purchased at market value or at extremely high prices so that the beneficiaries could enjoy a bumper crop at the time?
This is an answer.
Madam Speaker, I find in the quotation, the sheet, that it's mentioned that approved for installation, approved on instruction from the National Task Force chaired by the Prime Minister for installation. So I get the feeling that there were no procedures involved. it was a task force committee which took the decision which was chaired by the Prime Minister. And hence, the question of pricing, I'm not in a position to say, but it was all instruction that came from above.
Okay, yes, Mrs. Audia. Last question.
Thank you, Madam Speaker. B217.
Madam Speaker, I am informed by the Information and Communication Technologies Authority that for the period January 2015 to November 2024, the services of 49 barristers were retained by the authority. Madam Speaker, while preparing the response to this question, answered revealed that there was a similar question asked by Honourable Joanna Béranger on 29th November 2022. And the questions pertained to the names of the legal people and the cases to which the names related. And in reply, the then Prime Minister, to both parts of the question, he said that the answers are being placed in the National Library of the Library of the National Assembly. Hence, to a certain extent, denying that transparency to the public. Further research revealed that there was an attorney, SSO, who actually earned, in a period of 12 months, 2.8 million rupees. And the name, I can tell you the name of the company, and that comes next. A company by the name of Rebo Chambers. They bagged 6.72 million rupees in 12 months. And now we know the reason for which the then Prime Minister did not actually voice out the answer, but chose to go file the document in the National Library. Parliament Post, once again. Coming back to the actual answer of today's question at hand, and with regards to part A of the question, there was a total of 39 cases that were assigned to barristers. And as part 2 of the question, the legal fees amounted to 63.84 million rupees for 10 years. And that shows how public funds have been squandered. However, there were some names that come with insistence, Madam Speaker. There is ST.
Members, we have to listen.
With your permission, can I give the names, Madam
Of course,
Speaker?
but we have to listen.
Right. Right, so just give me one second and I'll come
These
up
are
with-
facts, Minister. Minister, these are facts.
These are facts, they are, fine. So there was the name of Barrister Trilochan, who bagged 22.18 million rupees out of 26 cases. That is a jackpot. Rebo Chambers, for 7 cases, they bagged 12.37 million rupees. And again, the name of SSO, that is Sona Ori, it comes again. Incidentally, or interestingly, in IT terms, SSO means single sign-on. It comes for 42 cases, 7.6 million rupees in the last 10 years. Now, this, to me, it sounds unacceptable. And we really see that there was a reason then for which the legal director of the ICTA was not recruited. And this position was left open for 10 years so that space could be made for such services of the cronies of the MSM government. Madam Speaker, thank you.
Thank you. Really, in one minute we finish.
Can the Honourable Minister inform the House what is being done to curtail such bad practices and ultimately avoid wastage of our public funds?
Sure, thank you. So I am tabling the details of the response here. And with regards to the question, the supplementary question, I'd like to add that this government takes good governance very seriously. And the ICTA has already advertised for the position of the legal director, and the applications have now been closed for the board to consider. Thank you.
Okay, one question on this side. He caught my eye.
Being given that large amount of money has been paid, which is a matter of public concern, would the Honourable Minister consider in the public interest to disclose the name of those beneficiaries and the amount that has been paid?
He will table the answer. He said he will table the full answer.
Yeah. What has been tabled actually pertains strictly to the question asked. But with regards to the supplementary question, I will table additional information, Madam Speaker. Thank you
very much. I suspend the sitting for 1.5 hours. Bon appétit.
Honourable members, the table has been advised that PQs B226 and B233 have been withdrawn. Yes. Honourable second member for Rivière des Ardilles and Suyac.
Thank you. Question B1 to 8, please.
Mr. Deputy Speaker. Mr. Deputy Speaker, I'm informed that in the year 2014, a total of 8,809 monkeys were exported as compared to 13,484 monkeys in the year 2024. The average selling price per monkey in the year 2014 was $2,235.60, that is 130 rupees, as compared to 6,424.53 USD. That is around 290,000 rupees, 621 in the year 2024. As regards Part B of the question, the annual revenue generated in the year 2014 was almost $20 million, approximately 1 billion rupees, as compared to $86,628 million, which is almost 4 billion rupees in the year 2024. I'm tabling information pertaining to the remaining years. For each monkey exported, the long-tail macaque, a levy of USD $200, equivalent to 9,035 rupees, is charged and is used for conservation initiatives across the country. The amount is relatively low, and I shall be reviewing this amount. Mr. Deputy Speaker, everyone in the House will concur that the issue of long-tail macaque has prompted heated debates. There are indeed a number of valid, legitimate, sensitive, but conflicting interests which are at stake. For a sizable number of animal lovers and militants in favor of the welfare of animals, the trading of long-tailed macaques should stop. Under international law, exportation of monkeys is lawful and is regulated by the Convention on International Trade in Endangered Species of Wild Fauna and Flora, whereby monkeys, breeding companies are issued a CITES-certificate export permit for all consignment being exported. From a biodiversity perspective, long-tailed macaque are an invasive species which has been negatively impacting the local native endemic and endangered biodiversity. From an anthropocentric angle, these long-tailed macaques constitute a danger to our agricultural farm and sometimes to the safety of citizens. Mr. Deputy Speaker, there is no short or long-term policy to date. In this context, a committee is being set up with all concerned stakeholders, including inter-alia ministries, academia, NGO, and the private sector, to look into all the aspects pertaining to exportation of monkeys. Any decision on that matter will be taken collectively with concerned stakeholders, subject to the agreement of government acting in public interest.
Okay. Honourable second member for Flack Bonacay.
Mr. Deputy Speaker, sir, B219, please.
Monsieur le Vice-président, j'ai été informé par la Central Water Authority que la mise en œuvre des projets de remplacement des tuyaux proposés dans les villages de Palmar, Cap-Coco, Bellemare, Mort-du-Puy a rencontré plusieurs défis. l'appel d'offres lancé par la Central Water Authority pour le renouvellement des tuyaux dans la région de Quatre-Cocos a dû être annulé 3 fois en raison d'offres non conformes à 2 reprises et d'un prix d'offres élevé à la 3e occasion. Monsieur le vice-président, je suis en outre informé par la Central Water Authority que le contrat pour le renouvellement de 1,5 km de tuyaux existant dans le village de Palma a été attribué à Great Standard Solutions Limited pour la somme de 8 500 000 le 31 mai 2024. De la même manière, un autre contrat pour le renouvellement de 1,5 km de tuyaux à Mort-du-Puy, Quatre-Cocos, le contrat a été attribué à Solcon Limited pour un montant de 9,9 millions de roupies le 18 septembre 2024. Les 2 projets n'ont pas pu être mis en œuvre. La CWA, comme je l'ai dit la semaine dernière, la CWA n'ayant pas respecté les dispositions de la loi sur le marché public en attribuant des contrats dont les montants dépassaient la valeur approuvée dans le projet. En bref, les 2 contrats ont été attribués alors que les fonds n'étaient pas disponibles. Monsieur le vice-président, comme je l'ai expliqué, comme je viens de dire la semaine dernière lors de notre session du 18 mars, des irrégularités ont été constatées dans la mise en œuvre des projets de remplacement de tuyaux au niveau de la CWA. Dans le budget 24-25, le montant approuvé pour le projet, petit projet jusqu'à 3 km, qui implique le remplacement de tuyaux d'une longueur de 1 à 3 km, s'élève à 1 milliard de roupies. Le projet, valeur de 1 milliard de roupies, réparti sur 3 exercices financiers. En 2023 et 2024, la CWA a attribué des contrats de remplacement des tuyaux à des petites et moyennes entreprises pour un montant supérieur à 1 milliard de roupies. Comme je disais, des contrats l'année dernière, à la veille des élections, des contrats distribués ici et là. Ce qui est contraire au principe du marché public. En règle générale, les contrats ne devraient pas être attribués que lorsque les fonds sont disponibles. Monsieur le vice-président, je suis informé que la valeur du projet a augmenté dorénavant de, comme je l'ai dit, 1,595 milliards de roupies, donc 595 millions de roupies en dépassement. Mon ministère devrait désormais s'adresser au ministère des Finances pour demander une augmentation de la valeur du projet et solliciter l'approbation du gouvernement sur la valeur révisée du projet de 1,5 milliard à peu près, conformément aux procédures en vigueur pour le projet d'investissement. Ce n'est qu'à ce moment que la CWA pourra procéder à la mise en œuvre d'autres projets de remplacement de tuyaux par des entrepreneurs de petite et moyenne taille, y compris les 2 mentionnés par l'honorable député.
Yes,
Monsieur le vice-président, puis-je demander à Monsieur le ministre, dans la mesure du possible, d'accélérer ce projet parce que les gens qui habitent ces régions sont obligés de boire de l'eau des tuyaux qui sont infestés d'amiante. Donc voilà, c'est une question sanitaire. Voilà, si vous pouvez prendre cela en considération.
Bien sûr, Monsieur le Président, nous avons déjà fait une demande auprès du ministère des Finances pour augmenter ce plafond-là. Mais vous savez, avec la CWA, il faudra avoir pas 2 yeux, mais 4 yeux pour surveiller ces gens-là. Mais je ne manquerai pas de voir ça.
Yes. Honourable Third Member for Beaubassin, Petite Rivière.
B220.
Mr. Deputy Speaker, sir, at the very outset, I wish to inform the House that the situation at the Mauritius Football Association was one of the most pressing issues that demanded my immediate attention upon assuming office. I was deeply concerned by the reports circulating in the press and felt it was imperative to address the matter without delay. To gain a comprehensive understanding of the situation, I promptly requested a full and detailed brief on the issue, particularly whether the election could be held. Mr. Deputy Speaker, sir, it is important to distinguish between the election that was held at the Mauritius Football Association and the eligibility of Mr. SS to stand as candidate. These are 2 separate issues. One does not preclude the other. Mr. Deputy Speaker, subsequently my ministry obtained a copy of the court ruling on the case of Mr. SS through the Ministry of Foreign Affairs. Thereafter, the advice of the Attorney-General Office was sought and the latter indicated that Mr. SS could be considered as eligible to stand as candidate to the National Managing Committee of the Mauritius Football Association. Mr. Deputy Speaker, with regard to part A of the question, I'm informed by the Mauritius Football Association that all procedures were followed as per the statutes and rules of the Mauritius Football Association Electoral Code. In fact, in the process leading to the election held on 27 November 2024, I'm informed that the Mauritius Football Association must adhere to strict and well-established procedures. Specifically, the MFA was required to publish a notice of the election in newspapers, which was duly done on 12 October 2024 in Le Défi Plus Daily. Additionally, the Mauritius Football Association was obligated to issue a further notice 10 days prior to the elections, confirming that the election would proceed as scheduled together with the official list of candidates. This requirement was also fulfilled in Défi Plus of 16 November 2024. The election was conducted under the supervision of representatives from FIFA and the African Football Confederation, and at the local level, Mr. DM, a retired superintendent of police, was entrusted with the responsibility of overseeing the electoral process. With regard to part A1 of the question, I'm further informed that only 2 individuals submitted their candidacies for the position of President, Mr. SS and Mr. ER. As for part A2 of the question, I'm also informed that, in accordance with the statutes of the Mauritius Football Association, any candidate for the position of President must be supported by at least 5 members. Unfortunately, Mr. ER was unable to secure the required level of support, whereas Mr. SS successfully met this criterion. Mr. Deputy Speaker, concerning part B of the question, I'm tabling, with your permission, the composition of the current Managing Committee of the Mauritius Football Association for the information of the House. Mr. Deputy Speaker, I wish to inform the House that while I'm fully prepared to report on matters pertaining to Sport Federation in relation to the obligation under the Sport Act 2016, it will not be appropriate to report on their internal affairs as such. The Sport Federation are autonomous entities similar to many other associations that receive various forms of support from the government, such as I can only report on issues pertaining to the federation that falls under the purview of the Sport Act 2016. In the meantime, Mr. Deputy Speaker, I would like to highlight that the Sport Act 2016 provides comprehensive provision for any individual who feels aggrieved by the action or omission of a sport federation. The Sport Arbitration Tribunal, an independent body established under the law, is specifically tasked with addressing such matters. Therefore, any aggrieved parties have the right to refer their concern to the Sport Arbitration Tribunal for appropriate redress. Mr. Deputy Speaker, sir, my ministry will not walk away from its responsibility of bringing order to the catastrophic situation which I inherited in the sports sector. We will bring order to this disorder. We are already working on the introduction of the National Assembly of a new sport bill that will address many of the seemingly unresolvable problems. I wish to conclude by stating that I will not condone any form of malpractice from any national sport federation which may jeopardize the interests of the sport community. Thank you, Mr. Deputy Speaker.
Yes, Honourable
Merci, Monsieur le Vice-président. Permettez-moi tout d'abord de dire que je suis en total désaccord avec ce que vient d'affirmer l'honorable ministre par rapport aux procédures suivies lors des dernières élections. Monsieur le Président, je me demande ma question est, comment le ministre peut-il justifier la candidature de quelqu'un, Monsieur SS, qui a été condamné à 1 an de prison avec sursis et une amende de 900 000 ayari pour violence physique, psychologique et morale à l'encontre de son épouse, alors que la Sports Act 2016, la loi suprême du pays en matière de sport, est claire là-dessus, et je cite rapidement la section 9.5c. No person, Monsieur le Vice-président, shall be eligible for election as a member of a managing committee of a national sports federation where he has been sentenced to imprisonment by a court for an offense. Donc, comment une personne condamnée peut être candidat à une élection fédérale? Et je vais déposer, Monsieur le Vice-président, copie de l'acte de condamnation de M. SS, accompagné d'une copie de la section du Sports Act que je viens de citer.
Is it a certified copy of the judgment?
Bien sûr.
I'm
Oui,
asking, it's a certified copy.
Non, vous pourrez jeter un coup d'œil si vous le voulez.
Honourable Minister?
Yes. In view of the Attorney General Office, in respect of the ESS election as follows, since Section 95C of the Sport Act simply refers to a term of imprisonment and is silent regarding, for example, a suspended sentence, peine d'emprisonnement avec sursis, a sentence whose execution is suspended pending appeal, etc., an interpretation of Section 9.5 could be that it was intended to apply to a person who is actually made to serve a sentence as imprisonment. Hence, on the basis of the above, it may be said that Mr. S could be considered as eligible to stand as candidate, as a state law office stated.
Je suis totalement, encore une fois, en désaccord. En plus de la Sports Act, qui a été transgressée avec l'accord de l'honorable ministre lui-même, il y a également le questionnaire for integrity checks de la MFA qui stipule à la section 1.4a, et je cite rapidement, an integrity check shall be deemed as not passed if the candidate concerned has been subject to criminal conviction or disciplinary sanctions by a state court, in particular if the underlying behavior was a substantive issue and not a minor infraction or procedural behavior. Avec cela, ce qui fait que la transgression de la loi du pays, il y a aussi des règlements internes de la MFA. Est-ce que, Monsieur le Vice-président, l'honorable ministre, considère-t-il pas que M. SS, après que j'ai énuméré tout ce qu'il y a contre M. SS, qu'il n'était pas qualifié pour être candidat à cette élection et de surcroît assumer la présidence?
The Honourable Minister has already been answered. The Honourable Minister stated that he is going according to legal advice, and he has acted on legal advice submitted to him. So we can't in this House challenge legal advice. So I take it that the answer has already been forwarded to you.
One last question.
Yes, but we can't challenge the legal advice upon which the Honourable Minister is acting.
Je vous comprends. Donc, pour clore sur ce dossier, Monsieur le Vice-président, le ministre a parlé des conseils qu'il a pris, qu'il aurait reçus avec la State Law Office ou le bureau de l'Attorney-General. Peut-il donc déposer une copie des échanges qu'il y a eu entre son ministère et la SLO et le bureau de l'Attorney-General, incluant...
Of course, I'm prepared to lay any document that's related to that.
This is the document between lawyer and the institution is privileged document which cannot be laid on the table of the Assembly. It's a privileged document between the client and the attorney.
I did by what the Deputy Speaker said.
No, sorry, what did you say? Okay. Sorry for the Vice President. The Honourable First Member for Warwick.
Thank you, Honourable Deputy Speaker. Question B221, please.
Mr. Deputy Speaker, sir, I am informed by the Information and Communication Technologies Authority that two mobile operators, namely Celplus Mobile Communications Limited, a subsidiary of Mauritius Telecom, and MTEL Limited, operate networks in Rodrigues and provide mobile network internet services. As at date, Celplus Mobile Communications Limited and MTEL have 23 and 16 base stations respectively and have deployed 5G, offering a maximum download speed of above 100 megabit per second in Rodrigues. Moreover, both Mauritius Telecom and MTEL provide home broadband internet services. Mr. Deputy Speaker, sir, as regards the quality of the internet in Rodrigues, I am informed that ICTA carried out between 30th June 2024 and 6th July 2024 an assessment exercise of the broadband to test the quality of service. The tests were conducted principally on the 4G mobile network that were deployed by both the operators. And this covered 92 locations. And that actually those 92 locations, they cover a majority of the inhabited regions of Rodrigues. Although the assessment exercise concluded that the mobile internet coverage was satisfactory across majority of the areas in Rodrigues, several regions such as Songe, Roseau, Rivière Banane, Pointe du Diable, and Rivière Pistache still suffer from poor coverage. And that is due to the topography of Rodrigues, which is a challenge, actually, to ensure maximum coverage. Therefore, MTEL has informed that 2 new mobile sites will be implemented during the course of 2025, namely at Mang and Rivière Banane. However, the long delays in securing clearance from the authorities in Rodrigues are hampering the setting up of additional sites at the moment. As far as connectivity by Celplus Mobile Communications Limited is concerned, a major network upgrade was undertaken in 2024 in order to enhance 4G services across all the existing sites and for the deployment of 5G network on all the sites. As part of its 25-26 expansion strategy, Celplus is planning the deployment of new sites. And the regions that will be covered are as follows. Baladirou Technopark and Port-Maturin. This will be done by September 2025. Montplaisir and Grande Montagne, which will be done by November 2025. And L'Union, which will be done by, which is due February 2025, which just passed. And that should have been covered. Celplus Mobile Communications Limited has requested assistance from local authorities in Rodrigues for facilitation of space and permits that are needed for the installation of infrastructure and locations that are aforementioned. Celplus has also informed that replacement and service restoration are undergoing, and this is being done at Mont-Lubin and are expected to be completed by May 2025. Finally, ICTA is currently implementing a quality service measurement platform that will allow any subscriber to test its internet service subscription and to communicate the results through an app deployed by the ICTA itself. In this respect, the ICTA will continue conducting regular quality of service measurement campaigns in Mauritius and Rodrigues too, and will publish comparative performance of different broadband internet service providers. It is believed that this measure will empower consumers to make informed choice of services and service providers and will motivate the internet service providers to improve their quality of service and in the interest of subscribers. Thank you.
Yes, Honourable François.
Just one supplementary. I thank the Honourable Minister for this extensive answer. May I ask the Honourable Minister whether he is aware that in 2023,
there were two major technical equipment failures at the level of Mauritius Telecom in Maurice, causing disruptions of services thereat. May I know from him whether there is any backup plan or link or redundancy plan for Rodrigues if any failures arise again in the future?
So, because the question was focused on the quality of service currently, not on the redundancy of service, the answer focused on the quality of service. With regards to the redundancy of service, I will revert at a later stage. Thank you.
Honourable Second Member for Mayberg and Planmayon.
B222. Mr. Deputy Speaker, sir, I'm informed that as at December 2024, a sum of 154,789,022 rupees has been disbursed by the Ministry for the operation, management and payment of the annual license fee in respect of the Liverpool Club International Academy. Mr. Deputy Speaker, I'm informed by the Mauritius Multisport Infrastructure Limited, a state-owned private company that has been entrusted with the responsibility for hosting the Liverpool Club International Academy, that since in inception in 2019, the latter has produced the following result. First, the enrollment of 650 trainees, out of which 75 are playing in national leagues. Second, 38% of the under 20 COSAFA men's team were Liverpool Club International Academy trainee, and 50% under 17 boys team were Liverpool Football Club International Academy trainees, 20% under 17 girls team were Liverpool Football Club International Academy trainees, and 24 Mauritian coaches have successfully completed the Liverpool Club International Coach Accreditation course.
Yes. I was hoping that one day we see a Mauritian player at Anfield, but I don't think so. But will the Minister state to the House when the contract was signed, the duration of the contract, and if this contract will be reconsidered?
Mr. Deputy Speaker, the contract was signed in June 2019 between Mauritius Multisport Infrastructure Limited and Liverpool Football Club and Athletic Grounds Limited. The contract is due to expire 31st May 2025. So government has decided that the existing agreement between Mauritius Multisport Infrastructure Limited and Liverpool Football Club and Athletic Ground Limited will not be renewed upon its expiry. The Mauritius Multisport Infrastructure Limited has been requested to work on winding up procedures and arrangement. The Ministry of Youth and Sport is presently working on suitable alternatives that will replace the Liverpool Football Club International Academy.
Honourable Second Member for Vieux-Grand-Port and Rosebel.
Thank you, Mr. the Deputy Speaker. Sir, it's question B223, please.
Mr. Deputy Speaker, sir, the Flak Maibo B28 road is a classified road that links several coastal villages such as Vieux-Grand-Port, Bois des Amourettes, Bambou-Verrier, Quatre-Sœurs, and Deux Frères. I am informed by the Central Water Authority that with a view to providing adequate water supply to the inhabitants of these coastal villages, it has embarked on a project for the renewal of the pipelines along the B28 road with the objective of addressing the long-standing issues of low water pressure, water leakages, and pipe bursts due to aging infrastructure. The pipeline renewal project is being undertaken in two phases, namely Phase 1 from Anse-Joncé to Bambou-Verrier to Petit Sable, covering a distance of 6.4 kilometers, and Phase 2 from Ferney to Anse-Joncé, covering a distance of 6.7 kilometers. Mr. Deputy Speaker, sir, in line with the provisions of the Road Act, the CWA made application for way leaves to the RDA for implementing the pipelaying works. Way leave for Phase 1 was granted on 2 occasions, namely on 19 June and 18 July 2024, for the stretch from Anse-Joncé to Bambou-Verrier to Petit Sable. For Phase 2, way leave was granted on 26 September 2024 from Ferney to Anse-Joncé. The way leaves were subject to strict compliance with the RDA way leave conditions for laying of pipes, ducts, and cables. In fact, the CWA and its contractors have to ensure that works are executed with minimum disruption and inconvenience to road users. In addition, any damage caused to the road infrastructure shall be made good at their own cost. These conditions include, inter alia, the following. First, temporary reinstatement of all trenches along the classified roads using crusher run and a 30 millimeter layer of asphaltic concrete as per specifications. Second, after completion of the permanent works for the stretch from Ferney to Bambou-Verrier, half widths of the existing road should be milled and resurfaced, and from Bambou-Verrier to Petit Sable, the whole width of the existing road should be milled and resurfaced. And thirdly, the works should be properly delineated with appropriate fluorescent bands. Mr. Deputy Speaker, sir, despite these measures, the RDA has raised concerns regarding the poor conditions of the temporary trench reinstatement along the B28 road. Several inspections have revealed that the reinstatement works were not up to the standard of the RDA, wherein the presence of a dangerous pits, crusher run having washed away or exposed to traffic were observed, therefore representing a serious threat to the safety of road users as well as the public at large. Accordingly, the RDA has issued several notices to the CWA, a recent one on 18 March 2025, requesting it to take immediate remedial action. Failure to comply with these conditions may result in the forfeiture of the 20 million rupees bank guarantee provided by the CWA for these works. As regards the villages of Quatre Sœurs and Deux Frères, no request for way leave was received by the RDA for pipeline renewal works. I am informed that the existing water pipeline, which is an old one, is subject to recurrent bursts and leakages, resulting in the asphaltic wearing course threat to be thereat to be damaged. The RDA has consequently requested the CWA to consider permanent pipe laying works at the earliest. Mr. Deputy Speaker, sir, I am further informed by the CWA that all works, including road reinstatement for the Phase 1 project, will be completed in this financial year, and those for Phase 2 will be completed in the next financial year. Additionally, a separate contract is currently being prepared by the CWA to appoint a Grade A contractor for the permanent road reinstatement from Ferney to Petit Sable. Same is expected to be launched under the open national bidding by April 2025.
The second member, Honourable Second Member for Flac and Bonacay.
Monsieur le Président, B224, s'il vous plaît.
Mr. Deputy Speaker, the Trust Fund for Excellence in Sports was set up under the Finance and Audit Trust Fund for Excellence in Sports, Regulation 2002. Its mission is to design, finance and implement projects and schemes for the benefit of, first, sportsmen and sportswomen who have achieved excellence in their respective field at national and international level, young athletes who have achieved excellence in their respective field at school level, and retired sportsmen and sportswomen who need support and financial assistance in order to embark on other professional activities. Mr. Deputy Speaker, I'm informed by the Trust Fund for Excellence in Sports that in pursuant of the aforementioned mission, it has established a program to support student athletes who are pursuing tertiary vocational studies locally and abroad. In this context, the Trust Fund has supported over the last 5 calendar years, that is from the year 2020 to the year 2025, 71 athletes at the sum of 13,263,716 rupees and 40 cents has been disbursed.
Yes.
Speaker, it takes 8 long years for a junior student, 8 long years of sweat and blood to become a professional athlete. Will the Honourable Minister confirm whether the amount disbursed has been slashed by almost 50% for all those athletes pursuing tertiary level studies?
Mr. Deputy Speaker, I've been aware that the quantum allocated to the athlete pursuing tertiary education has been reviewed by the previous board from 260,000 to up to 2,000 per academic year based on a revised set of performance-based criteria. The newly constituted board of the Trust Fund will assess the existing scheme holistically and will come up with a proposal in due course.
Monsieur le Vice-président, si je comprends bien la dernière réponse de l'honorable ministre, un nouveau board vient d'être constitué et peut-on savoir qui c'est qui est à la tête de ce board?
We will lay the list of all the members in the table of the Assembly.
The Honourable Second Member for Warwick.
Yes, thank you. B225.
Mr. Deputy Speaker, sir, in regard to Part A of the question, I am informed by the National Heritage Fund, a parastatal body operating under the aegis of my ministry, that there is currently no national policy in place specifically dedicated to the protection of national heritage sites from natural disasters and the impacts of climate change. This is a serious concern, especially as Mauritius, being a small island developing state, is increasingly exposed to extreme climate-related hazards such as cyclones, torrential rainfall, rising sea levels, flooding and coastal erosion, all of which pose significant risk to our cultural heritage. Mr. Deputy Speaker, sir, while no national policy was developed or implemented by the previous government to address this challenge in a comprehensive and coordinated manner, some isolated efforts were made in response to obligations under the World Heritage Convention. As such, I am informed that there is a disaster risk management plan for the Apravasi Ghat World Heritage property, and there is a draft plan which is under preparation for Le Monde cultural landscape. These were initiated as part of UNESCO World Heritage Sites requirements. However, for the vast majority of national heritage sites across the country, no disaster preparedness or climate adaptation measures have been systematically adopted, nor has the legislation been updated to reflect these urgent needs. Mr. Deputy Speaker, sir, this government has placed this pressing concern high on its agenda, recognizing that the conservation and safeguarding of our national heritage must go hand in hand with disaster and climate resilience. This priority is clearly reflected in the government program 2025-2029, a bridge to the future, which pledges to strengthen cultural identity and reinforce the protection and valorization of heritage sites. Accordingly, the National Heritage Fund Act 2003
which is now outdated, will be reviewed. A new National Heritage Authority bill will be drafted to include, inter alia, emergency preparedness plans, integration of climate change adaptation into conservation planning, and use of modern tools such as artificial intelligence and 3D scanning to document, monitor, and protect heritage assets. Mr. Deputy Speaker, sir, in regard to Part B of the question, I am informed by the National Heritage Fund that it did not receive any request from the Chief Commissioner's Office of the Rodrigues Regional Assembly for the renovation or demolition works of the residency building in Port-Maturin, Rodrigues. However, during a visit in Rodrigues carried out by two officers of the National Heritage Fund on 18th March 2025, at the request of the Rodrigues Tourism Office, the two officers were informed that a tender had already been awarded for the repair and restoration of the residency building. Thereafter, the two officers were called upon to attend a meeting with the departmental head of the commission, whereby more details of the renovation project were communicated to them. Since the building is a national heritage since 2001, the departmental head was informed that prior to any repair or restoration works, the clearance of the National Heritage Fund should have been sought as stipulated under Section 13(3) of the National Heritage Fund Act 2003. I am further informed, Mr. Deputy Speaker, sir, that the National Heritage Fund has on 20th March 2025 instructed the Island Chief Executive to stop all works thereat with immediate effect and to submit a detailed clarification on the matter to enable the Technical Committee of the National Heritage Fund to examine same and thereafter make appropriate recommendations to the National Heritage Fund Board. Thank you.
Yes. Thank you, Honourable Minister, for his answer. May I ask the Honourable Minister whether the NHF Board will consider the identification of additional sites or monuments deserving to be designated to the status of historical and cultural heritage site in Rodrigues, just to name a few, such as St. Gabriel Cathedral, Mauritius Telecom Building at Mont Venice, and also the lost recoverable terraces remain at Dansamy.
Yes, of course, we'll do it.
Yes. One last question?
No, I have two. Just if you allow me, Mr. Speaker, very important. With regards to, as per Schedule Section 2 of the Act, NH National Heritage of Mauritius Territorial Rodrigues, out of a list of 6 sites, there is only one private property, namely Ben Gontran House at Barclay Street, Port-Maturin. May I seize this opportunity to humbly ask the Honourable Minister to request the National Heritage Fund Board to discuss with a private owner for necessary measures and support as may be necessary to maintain and protect this house so that it does not lose its national heritage identity and value. Thank you.
Yes, Honourable Member, I will ask the National Heritage Fund to do so. Thank you.
Yes. The Honourable Second Member for Grave, Cotonou. Question has been withdrawn at the set? Yeah, withdrawn. Okay. The first member for Montagne Blanche and Grande Rivière, Southeast.
Mr. Deputy Speaker, sir, B 227.
Mr. Deputy Speaker, I'm informed that Belair Rivière Sèche State Secondary School was constructed some 15 years ago. I wish to inform the House that the riverside of the school is secured with 1.8 meters chain link fencing. This was meant to be a deterrent for students to leave the school premises and have access to the river. However, I have to admit that the fencing does not prohibit intruders from entering the school. I'm also informed, whilst the fencing is still in good condition, yet it might not have been placed at the right place. Mr. Deputy Speaker, with a view of enhancing security at the school, I have instructed that the possibility of having another fence be explored along the alignment of the existing retaining wall over a stretch of some 120 meters, further upwards, which would be a more suitable deterrent to intruders. This new proposed structure would go a long way towards ensuring the safety and security of our students. Mr. Deputy Speaker, I wish to inform the House that, subject to technical feasibility and availability of funds, this work can be completed in a short span of time, approximately 4 weeks, as from the date of start of works.
The Honourable First Member for Lacaverne Felix.
Mr. Deputy Speaker, B228, please.
Mr. Deputy Speaker, sir, I am informed that the Phase 3 of the Metro Express project, which pertains to the extension of the metro line over a distance of 3.4 kilometers from Rose Hill to Redri, was implemented following a decision taken by the then government on 30th December 2020. I would like here, Mr. Deputy Speaker, sir, to remind the House that at that time, according to records available at my ministry, the light rail project was being spearheaded by the then Prime Minister's office. Mr. Deputy Speaker, sir, with regards to Part A of the question, I am informed by Metro Express Limited that a proper feasibility study, that is, a proper technical and financial study, was not carried out for Phase 3 of the Metro Express project. In fact, the decision to proceed with the project was made following a case put forward by the consultant for the project, Singapore Corporation Enterprise, in 2016, in its reference design. The consultant had identified the regions of Eben, including the Cyber City and Redri, as a critical commuter base, which justified the need for an efficient mass transit. The then management of MEL, Metro Express Limited, estimated the number of commuters to be 30,000 at Eben and 11,000 at Redri. Mr. Deputy Speaker, sir, I am informed by MEL that this line has much lower commute figures, averaging daily 3,200 commuters on weekdays, 1,490 for Saturdays, and 522 for Sundays. The total fare amount generated for year 2024 is 30 million rupees, 736,428, resulting in an average monthly amount of 2,561,369 rupees. Worse, if we take the fare amount for last month, February 2025, it's only 1.7 million rupees. That is much less than the expected ridership income. It is therefore evident, Mr. Deputy Speaker, sir, that MEL is operating at a terrible loss over the line. Mr. Deputy Speaker, sir, during the previous mandate, I had on 2 occasions, personally myself, drawn the attention of the House and the population at large, firstly, in the much debated parliamentary question B223 of 18 April 2023, and the next one, 1 month later, PQB 596, that the project was not workable. In fact, I had used the word total failure. It's in Hansard. When we take into account that the cost of Phase 3 stood at 4.455 billion rupees, which is the figure the Honourable Lobin had requested for in Part B of the question, a simple calculation shows that this tantamount to 1.3 billion rupees per kilometer without any cost of train. That is 1,3 million de roupies, 1,34 million de roupies per mètre linéaire de voie ferrée. This much, 1 meter. This costed 1.34 million rupees on average, from Rose Hill to Redri. It costed quite a lot. Mr. Deputy Speaker, sir, these 4.55 billion rupees worth of works were effected through a variation to the existing main contract for Metro Express project with Larsen and Toubro. This amounts, coincidentally, to 24%, slightly less than the prescribed threshold of 25% of the equivalent of 18.8 billion rupees for the main contract. Mr. Deputy Speaker, sir, as a professional of the construction industry, I've always viewed this particular course of action adopted by the then government for this particular variation as being highly debatable, because the extension per se was not along the line QPIP to Port Louis, but was in a completely distinct new line from Rose Hill to Redri, which is not in the direction of the main metro line, which costed 18.8 billion rupees. Mr. Deputy Speaker, sir, with regard to further extension of the metro line, I'm informed that a feasibility study was carried out in October 2021 by a team of Metro Express Limited with the technical assistance of Rights Limited. This study covered the extensions of the metro line from Redri towards Côte d'Or and Saint-Pierre, and from QPIP to La Vigie. The report was submitted in April 2022 at a total cost of 21.98 million rupees, nearly 22 million rupees, out of which 18 million was paid to Rights and 3.98 million rupees to the in-house team at Metro Express Limited. No tender exercise was done for this consultancy exercise. Mr. Deputy Speaker, sir, I wish to point out that on the procurement process for the construction of under Phase 4 of the Metro Express project was cancelled by the Empowered Interministerial Committee of the Government of India in September 2023, and that the project is currently put on hold as advised by the Exim Bank of India. Thank you.
Yes.
May I ask the Honourable Minister, with regard to this total failure of the Metro Express project, will his ministry conduct a comprehensive and full-fledged study with regards to the impact now on the coffers of the state with regards to further money that this government will now have to pour in to make this workable in view of this total failure of Metro Express that have been implemented?
Certainly. We are implementing measures. As a matter of fact, I've given instruction to stop the train working on Sundays because it's a total wastage. As regards the other days, we will be working on it and to try and see how to enhance ridership on that line.
The Honourable Third Member for Port Louis South, Port Louis Central.
B229, please.
Mr. Deputy Speaker, sir, first of all, let me thank the Honourable Member for this question, and also let me take this opportunity to congratulate the Honourable Member for his National Day Award 2025 as Grand Officer of the Order of the Star and Key of the Indian Ocean for his contribution in the medical and social fields. Mr. Deputy Speaker, sir, I wish to inform the House that persons suffering from a disability are entitled to an invalid basic pension or a disability or a disability allowance and/or a carer's allowance after an assessment by a medical board. Under the prevailing system established prior to the present government, a medical assessment is carried out by medical practitioners of my ministry to determine the eligibility to the invalid's basic pension or disability allowance or carer's allowance. Assessments are carried out either by a medical board, which comprises of 2 medical practitioners, or by 1 medical practitioner at the claimant's residence for those whose mobility is limited and who cannot attend the medical board. As per law, the entitlement for the invalid's pension is based upon the claimant being at least 60% incapacitated for a period of at least 12 months. The law as such does not make any provision for the duration of any of the pensions. A medical guideline, last updated in 2016, in collaboration with the Ministry of Health and Wellness, is used by medical practitioners who sit on medical boards for assessment of claimants for the benefits. This guidelines also provides for the duration of the award of the disability benefits. Statistics recently compiled by my ministry reveal that under the present system, 1 in 2 cases where pension benefits are approved, they are for a period of 1 year. In 32% of cases, pensions are awarded for 2 years. This means that every year, more than 50% of invalidity pensions or benefits claim being assessed relate to renewal cases. That is cases where pension has lapsed and thus need to be reassessed for renewal. This is one of the reasons why many Mauritians are dissatisfied with the present system. Mr. Deputy Speaker, sir, to reply to Part A of the question on how many cases have been cancelled for the last 4 years, please allow me to make some clarifications. Disability-related pensions and benefits can be stopped for 2 reasons. First, they can be suspended in departure cases or in cases of free consecutive non-encashment of pension, or where doubtful documents were produced by applicants or malpractices have been reported by whistleblowers. Second, pension and benefits are discontinued after the duration period of the pension has lapsed, and same has not been renewed by the medical board. With regard to Part A of the question, I'm informed that for the period July 2021 up to 20th March 2025, there were 335 suspended cases of BIP, basic invalid pension, disability allowance, and carers allowance. Additionally, 16,134 cases of BIP, disability allowance, and carers allowance have been discontinued for the period of July 2021 up to 20th March 2025 after reassessment by the medical boards. Moreover, 29,013 cases of BIP, disability allowance, and carers allowance have been disallowed, that is, not granted, by the medical boards for the same periods. It should be pointed out that for the same period, my ministry has received 33,360 applications for basic invalid pensions, 1,179 applications for disability allowance, and 42,915 applications for carers allowance. For the benefit of the House and the public, I am tabling indicative statistics on what I have been just mentioned. With regard to Part B of the question, I wish to inform the House that under the present legislation, a person whose case has been disallowed or discontinued or only provided a statement that the claimant has not satisfied the 60% incapacitated criteria. The onus to prove the contrary is put on the claimant, who has the right to make an appeal to the Medical Appeal Tribunal within a period of 1 month from the date of disallowance notice. In case claimants do not appeal, they may make a fresh application to the medical board for the benefit after 6 months. An earlier application can be made in the event that there is an aggravation of the medical condition of the person, so it's supported by a medical certificate. As for measures envisaged by my ministry, I need to highlight that the current system is based on medical guidelines, and the assessment system is based on medical guidelines and the 6th schedule of the National Pensions Act. Thus, a broad-based reform is being explored to include the functionality of a potentially disabled person. That is, can the person work? Can the person feed himself or herself? Can the person use public transport? Can the person take care of himself? Just to mention a few examples. In addition, my ministry is also exploring the reform of the entire operation of medical board. Shall the board have access to the entire medical file of the claimant and perform its operations within public hospitals and centers, as is presently the case for the claims based on eye vision disability? Shall the doctors serving on medical boards and carrying domiciliary visits continue to be employed on a sessional contract basis? Or shall they be the backbone of a new system? Proposals are being considered to include representatives of organizations representing people with disabilities within the medical board and appeal tribunal dealing with disabilities benefit entitlements. Furthermore, the very criteria of 60% incapacity is being questioned. The possibility of introducing a graduated benefit system based on the percentage of incapacity and functionality is being explored. We are studying different systems from different countries in this respect. In the long run, the introduction and the talking of e-health system with the e-social security system will greatly facilitate the efficiency and modernization process once we settle the core issues on the coming reform. To conclude, Mr. Deputy Speaker, sir, my ministry, with the support of the government, is moving towards a significant change of the system to ensure a dignified, right-based, and efficient disability pension benefit system in Mauritius. In this context, to promote inclusiveness, my ministry has opened, as from 18th March until the 10th April 2025, a last round of input from citizens and associations defending people with disabilities to formulate proposals for changes in disability pensions and benefit system, as well as amendments they deem appropriate to the not yet proclaimed the Protection and Promotion of the Rights of Persons with Disabilities Act 2024. Thank you, Mr. Deputy Speaker.
Thank you for your long and comprehensive answer. No additional. You have a supplementary? No. One last supplementary, because the answer was quite comprehensive.
Yes. Thank you, and thank you for the compliment at the beginning of your answer. May I ask the Honourable Minister, based on the medical assessment that we have at the present by medical practitioners and the medical board, whether he would also consider the implementation of a barema system, the barema system which is being used widely in Europe, and I have copies of them from different countries which I'll hand over to you afterwards, that can encompass the medical, functional needs, assistance needs, and above all, the additional costs incurred by relatives. I'm just hoping that this can be implemented. And my next, there's a small question. This is a very sensitive issue. It's on the radio every day. Very sensitive. I would like to ask the Honourable Minister that there should be in the department an emergency appeal system rather than the normal appeal, an emergency appeal system with regards to certain individuals who have been invalid since birth, whose conditions have not changed, but have all been denied of the invalidity pension, namely of one case that may make history for him, of a young boy born epileptic, cerebral palsy, one arm longer than the other, one leg shorter than the other, who cannot talk, and yet his pension has been denied. I will share the documents with you. Please look at how these individuals who are bona fide invalid people can have an emergency system for your ministry so that they can have the funds to have a better living. Thank you.
We are on the same wavelengths. Since I took this office, we share the same concern and we are studying in the same direction. All these suggestions and the documents that you will submit will be considered. Thank you, Honourable Member.
The Honourable First Member for Savannah and Black River.
Mr. Deputy Speaker, sir, the Plaine Champagne B103 road starts at Lemar and ends at Chamarel village and is approximately 13 kilometers long. Several significant signs of distress and road edge failures were noted along a stretch of 1 kilometer of the B103 road, specifically between Chamarel-Romery and Varennes-sur-Maune, which required rehabilitation and grading along that segment. A project for the upgrading of the road and slope stabilization works was accordingly implemented by the Road Development Authority. Works have been substantially completed and the road reopened to the public on 20 February 2025. I am informed by the RDA that while major construction works have been completed, there are some minor works and monitoring activities which are still ongoing. As regards road safety survey, I am informed by the Traffic Management and Road Safety Unit, TMRSU, that a road safety audit is usually conducted in the context of the construction of a new road to see whether road safety may be improved on the road prior to its opening. The TMRSU has further informed that in the case of the B103 road, the works comprise slope stabilization along a small stretch of the existing road, and accordingly, a road safety audit was not required. However, a site visit was carried out by the TMRSU and several road safety improvement measures have been recommended, namely placing of handrails and guardrails, which I'm informed have already been implemented. In addition, as part of the project, the RDA has submitted road marking, traffic signage, and other road furniture details to the TMRSU for approval prior to implementation. Given that the road is still being monitored jointly by the TMRSU and the RDA, a site meeting will be held by both parties by the end of March 2025 to identify additional safety measures to be implemented if required. Mr. Deputy Speaker, sir, as regards Part B of the question, it should be highlighted that the road is heavily bounded by trees and vegetation. Prior to the opening of the road, the contractor on the project had carried out a first cleaning and trimming of trees within the 1 kilometer segment of the road where the works were ongoing. The cleaning and trimming of trees along that stretch are still ongoing and will be completed by the end of this month. Only last Monday, during the management meeting at the level of the RDA, I highlighted that I was not satisfied with the lopping of branches along B103 road and requested the RDA to take urgent remedial actions. The RDA has accordingly committed to complete the cleaning and trimming of trees along the remaining section of B103 road very soon. Subsequently, this will form part of the ongoing routine maintenance program by the RDA's maintenance section.
Yes, sorry, I will call B230 now. Honourable Third Member for Porty South.
B230, please.
Mr. Deputy Speaker, as regards to part A of the question, I have been informed that the Immaculée Conception School is no longer being used for educational purposes since 2012, given its state. I'm also informed that the premises where the school was formerly housed were officially handed over to the Mauritius Police Force in April 2017 for the setting up of a police warehouse. Following complaints received on the Citizen Support Unit portal in 2021 by inhabitants of the region, my ministry took note that the Mauritius Police Force did not go ahead with the said project. Moreover, the Ministry of Housing and Lands has informed my ministry on 12 October 2021 that the premises are under its control but were being occupied by the Field Services Unit, a department falling under the aegis of the Ministry of Local Government. Therefore, this school no longer falls under the purview of Ministry of Education and Human Resources since April 2017. Mr. Deputy Speaker, as regards to part B of the question, my answer is yes. We are conscious about the insecurity there. Complaints from the public were made to my ministry in 2021 pertaining to drug addicts and dangerous squatters occupying the premises. The Ministry of Housing and Lands was accordingly requested to undertake necessary and appropriate actions, given that the land on which stands the ex-Immaculée Conception School is under the control of the latter ministry. Additionally, the Mauritius Police Force was requested to reinforce police patrol around the premises of the school and take necessary actions against the illegal occupants for the safety and security of the public. This request was reiterated this year again. Thank you.
The Honourable First Member for Port Reitz North and Mount Island.
Thank you, sir. B232.
Mr. Deputy Speaker, sir, the House is aware that I have been replying to several parliamentary questions recently about the pool level of bus transport service island-wide, and I believe this is also the case for regions which the Honourable Member has referred to a question today. In fact, the House will recall that I have also made several public announcements in and outside the House, stressing on the prevailing malaise in the bus industry. I seize this opportunity to reassure the House and the travelling public at large that the improvement of the level of public bus transport is one of my priorities. We, at the level of my ministry, are fully committed to look for workable solutions with a view to improving the services around the island in line with the numerous measures which I have already enumerated in the House during my previous replies. Now, coming to the region of Vallée des Prêtres, Chitrakoot and Caroline, Mr. Deputy Speaker, sir, I am informed by the National Land Transport Authority that the public transportation services in these localities are exclusively offered by the United Bus Service through the following routes. Route 41, Vallée des Prêtres, the new transportation center. Route 41A, Upper Vallée des Prêtres. Route 160, Vallée des Prêtres, new transportation center again. Route 160A, Upper Vallée des Prêtres, Cité Valégie. And Route 237, Vallée des Prêtres, Mont-Selmon-Rafré-Paille. I am further informed that 13 road service licenses have been granted to the United Bus Service to operate its buses along the aforesaid routes. In accordance with the established timetable, buses along Route 41, 41A, 160 and 160A should operate at 30 minutes interval during peak hours and on an hourly basis during off-peak periods. As regards to Route 237, buses are required to ply at an hourly interval throughout the day. The hours of operation along these routes are 5 o'clock in the morning and 5:25 to 8 o'clock at night. Mr. Deputy Speaker, sir, I wish to also point out that inspections conducted by the NLTA Inspectorate have revealed that the UBS buses plying in the regions which I have just mentioned are not adhering to the prescribed timetable, and this has undeniably resulted in complaints from commuters thereat in respect of service, delays and inconsistencies. The NLTA Inspectorate has in fact pointed out that the UBS is operating at a lower number of buses out of its operational fleet, and this situation has been observed across all its route island-wide. It's a malaise actually right now. Despite their being availed of free transportation service. To this effect, I've been informed that the NLTA has had dedicated meeting with the traffic manager of the UBS on 30th August 2024, whereby the latter was apprised of the issues and complaints. The representative of the UBS undertook to take remedial actions, highlighting the main cause thereof related to the shortage of drivers, and that necessary arrangements were underway for the recruitment of foreign labor. The representative of the UBS was once again convened at the NLTA last month, that is in February 2025. In view of the persistent situation, it would seem there has been no improvement so far. Mr. Deputy Speaker, sir, I would like to inform the House that I can humbly state that after 4 months in office, that I've been able to understand the problems being encountered by the travelling public and the reasons thereof, which are multi-pronged. Let me give you 3 reasons. Firstly, I'm inclined to strongly believe that the issue of recruitment of foreign workers have become some sort of a pretext for several bus operators to keep their buses in their garage while benefiting at the same time from government subsidies monthly. This is across the board and across all companies. Unfortunately, it is a malaise right now. But secondly, I've been made aware that various representations I have received from several bus operators, they do not treat their employees properly, and hence potential candidates are reluctant to join these companies. Thirdly, and they don't realize that importing foreign labor can be more expensive. Thirdly, in some cases, bus operators have resorted to employing drivers and conductors who are not fit and proper for the job. And this has led to the alarming and dangerous situation whereby we are having cases of bus crew operating under the influence of alcohol and drugs. I've had extensive meetings with the Mauritius Police Force during the course of last week and even before that, to try and address this situation. The recent accident which occurred at Solitude, whereby a school bus was being driven by a conductor who was not only under the influence of illicit drugs, but was not even the holder of a valid driving license, is telling of the situation we are in right now. Mr. Deputy Speaker, sir, let me reassure the House that the introduction of the fleet management system, a project on which my ministry is actively working on, will be a game changer for the bus industry, and that will certainly redress the issue of inadequate buses and non-adherence to established timetable. The request for proposal is currently being worked out by the consultant, and hopefully the project will be in place by the end of this year. Nevertheless, in the meantime, based on the recommendations of the NLTA regarding the timetable, plausible remedial actions, or the immediate plausible remedial actions, I've asked the latter to consider, the NLTA, the possibility of licensing additional RSLs according to Section 77 of the Road Traffic Act 2023, which empowers me to do so, to other bus operators in order to improve the level of service in the regions where inhabitants are encountering acute transport problems, including the regions mentioned in the question of the Honourable Member, and I'm waiting for a reply from the NLTA. Thank you.
Yes, one question.
Thank you, Mr. Speaker, sir. Bus transport is a real headache in the regions that I've mentioned in my PQ, Vallée des Prêtres, Chitrakout and Caroline. Monsieur le Député Speaker, il est déplorable de constater que certains autobus de la United Bus Service sont âgés de plus de 15 ans lesquels sont bons pour de la vieille ferraille, sont toujours en circulation dans la circonscription, à l'instant dans les régions citées à l'instant. Donc ma question, alors, est-ce que le ministre compte ouvrir des lignes à d'autres compagnies d'autobus? Clearly, there's no will from the side of the actual bus operators to improve their services there. Can the Honourable Minister ask the Inspector of the NLTA to be more active there until the situation improves? Thank you.
Repeat what you have just said, the last phrase.
The end of a lifetime of a bus is 20 years old, legally. So 50 years is 5 more years to go, but that is not the reason why the bus should not be in good condition. So I will look into the issue for the specific buses plying that route, and we'll come back to the member for due course.
The Honourable Second Member for Mayberg and Glenmany.
234.
Okay. Mr. Deputy Speaker, sir, I am informed by the National Land Transport Authority that prior to the amendment which was brought to Section 77 of the Road Traffic Act in 2023, no temporary road service licenses were granted. However, I am informed that during the period 24 October 2023 to 16 September 2024, 45 road service licenses, temporary road service licenses, have been granted for the operation of buses, that is 42 in Mauritius and 3 in Rodrigues. And the Rodriguan ones are under judicial review right now, following application made by the Mauritius National Assembly, the General Assembly. I would wish to point out that according to information provided to me, approval was obtained from the then Minister of Land Transport and Light Rail for 13 other road service licenses on 1st October 2024, but these licenses were not issued by the NLTA as the general elections were imminent. That was 4 days before the Parliament was dissolved. These RSL have been granted under the provisions of Section 77D of the Road Traffic Act, which were introduced in 2023 under the Road Traffic Amendment Act number 10, which came into operation on 17 July 2023. This section of the law, in fact, empowers the Minister to either, 1, direct the NLTA to allow an existing licensee to redeploy his bus from an existing route to another, or, number 2, direct the NLTA to grant a new road service license to an existing licensee to operate services along a route designated by the Minister. In both instances, the Minister has to ascertain that the redeployment of any bus or the grant of a new license is in the public interest based on a report from the NLTA to the effect that the redeployment or grant of license is justified and that there is a need to supplement the service along any designated route. The Minister, while directing the NLTA, has also to specify the duration for which the license is to be granted. Mr. Deputy Speaker, sir, according to the NLTA, all 45 new licenses have been granted following applications submitted by existing licensees to the then Minister for specific routes. The NLTA then submitted a report on the need for supplementing bus services along the route applied for. The then Minister subsequently directed the NLTA to issue the license. Another pertinent observation was in respect of the grant of these temporary licenses is that the law clearly stipulates that where the Minister is satisfied that a particular route or area is inadequately served and that in the public interest to improve bus service on that route or area, he may direct the NLTA to grant a road service license for such duration he may deem fit. The word duration is listed there. To an existing licensee so as to allow him to operate bus services on such route or area designated by the Minister. End of quotation. However, it is worth pointing out that although it is the prerogative of the Minister in law to determine the duration for which the license is to be granted, such was not the case, I'm given to understand. It would seem, therefore, that the NLTA has taken it upon itself to decide on the temporary licenses to be for an initial period of 3 months. I'm also being made aware that these temporary licenses have been subsequently been renewed for additional periods of 3 months administratively, solely at the level of the regulator, which is the NLTA. I've also been informed that in the case of the 45 new licenses issued, officers of my ministry were not at all involved in the whole licensing processes. Sealed confidential files moved to and fro between the NLTA and the office of the then minister. The ministry did not have the slightest hint of the rules where licenses were being granted, the manner in which the existing licensees were becoming aware that they should submit applications to the minister for any specific route, and of the mechanism as to how the NLTA was requested to submit report on the level of service. Nothing could be found in any file in my ministry, I am told. I am further informed that the whole licensing exercise seems to have been carried out in strict confidentiality, both at the level of the then minister's office and the NLTA. As a matter of fact, there have been several representations from operators as to the manner in which these temporary road service licenses have been granted, and I'm inclined to think that these may have prompted the Honourable Apollo to come up with this question. The Honourable Member may rest assured that since I took office at the Ministry, I have stressed that henceforth all legal and administratively established processes should be strictly adhered to. Mr. Deputy Speaker, sir, as regards Part B of the question, I am informed that the established administrative procedures have not been duly followed, and it would appear that, number one, the then Minister was approving the applications for temporary road service licenses without referring these files through proper channel, that is the administration, resulting that in fact there is no record regarding these applications and the grant thereof at my ministry. I am informed by the NLTA that the officer in charge of the NLTA took it upon himself to grant these temporary road service licenses for an initial period of 3 months, despite the fact that such duration should have been specified by the Minister as provided under the law. In the light of the above, I wish to reassure the Honourable Member and the public that I have already given instruction for an inquiry to be conducted properly, as per the request of the Honourable Apollo in his main question for an inquiry. In the event any malpractice is confirmed in the manner these temporary licenses have been granted and or renewed, necessary actions as may deem necessary will be initiated accordingly. Additionally, an assessment will be undertaken as to whether these temporary licenses are still required. In the affirmative, the NLTA will be requested to open up applications for permanent road service licenses to be granted along the relevant routes for the benefit of the travelling public. Finally, I wish to enlighten the House that the buses licensed with a temporary road service licenses are benefiting from free travel compensation monthly. Thank you.
Mr. Deputy Speaker, thank you, the Honourable Minister. According to your answer, I think a full-fledged inquiry should urgently take place. Can the Honourable Minister table the list of those who have been granted these licenses and also the list who have not been granted? And can the Minister confirm to the House who signed all these documents?
Yes. I will table all the requested information from the Honourable Member. For those who were issued a license, for those who were made application, but which were not issued a license because elections were imminent, and I think the signature of the Honourable Minister Ganu is there. So,
the Honourable Second member for Belrose and Cadbourne.
B 235, merci.
Mr. Deputy Speaker, sir, I am informed that the junction of Victoria Avenue, Sir Guy Forget Avenue, and Avenue Belrose is a signalized cross junction found along the Metro Express corridor. The signalized cross junction falls under the traffic signal priority system, which is managed by the Metro Express Limited. The signalized cross junction caters traffic movement in 8 directions, so quite busy, as well as for train movement. The traffic signal sequences were configured thereat following a traffic survey carried out in 2018 based on the train movement and traffic volume and traffic flow. Mr. Deputy Speaker, sir, with the present configuration, the train has priority signal at this junction, as is the case at all Metro Road junctions. Additionally, traffic along Sir Guy Forget, which is a one-way street towards Belrose Avenue, is provided more green time in the morning peak due to higher volume of traffic. Similarly, additional green time has been allocated for traffic coming from Victoria Avenue in the direction of Cadbourne in the morning and vice versa in the afternoon, based on the traffic survey of 2018. Mr. Deputy Speaker, sir, almost 6 years have passed since the traffic light thereat has been configured, and traffic patterns may have evolved during these years. The Metro Express Limited has already been requested to carry out a fresh survey in collaboration with the Traffic Management and Road Safety Unit of my ministry to that effect, and with a view to adapting the configuration of the traffic light based on the findings. The exercise is expected to be completed in 1 month's time. I have therefore to thank the Honourable Member for coming up with this question, as it has given technicians of my ministry the opportunity to question the relevance of the 6-year-old configuration.
Yes, one question.
Je vous remercie, Monsieur le Vice-président. En effet, nous avons reçu, le docteur Boulel, vous-même et moi, de nombreuses plaintes des usagers de la route concernant les embouteillages au carrefour de l'avenue Victoria et de l'avenue de Belrose à Cadbourne. Will the Minister inform the House if his ministry will envisage to introduce smart traffic light system, communément appelé en français des feux de signalisation intelligents, that adjust based on real-time traffic conditions to enhance efficiency? Thank you, Mr. Deputy Speaker.
Yes, I thank the Honourable Member for this question. We are actually working in that direction. There is a consultancy exercise that my ministry is conducting now, and it is called Adaptive Traffic Control System, which have as qualities, I must say. It is being smart because it uses artificial intelligence to monitor traffic, and it will henceforth, if going forward, prevent long waiting time when there are no cars, for example. So, and also red light cameras. If someone brûle feu rouge, par exemple, it can spot. So we are working in that direction.
Okay, one last question we'll take for this session. B236. Honourable Second Member for Belrose Cadbourne.
Je vous remercie, Monsieur le Vice-président. B 236.
Mr. Deputy Speaker, sir, I am informed that the report of the fact-finding committee set up to shed light on the circumstances that led to baby S being admitted to the neonatal intensive care unit NICU of the Sir Sivasagar Ramgoolam National Hospital on 21st October 2022 was handed over to the then Minister of Gender Equality and Family Welfare on 22nd November 2022. Mr. Deputy Speaker, sir, I'm further informed that the committee was mandated to carry out an in-depth inquiry and to submit its report on the basis of the terms of of reference as follows. A. Investigate into the circumstances leading to the baby being admitted to the NICU. B. Investigate on the management of and services being provided to the baby. C. Investigate on the management of the residential care institutions, shelters for children falling under the purview of the National Children's Council in general. And D. Make recommendations for 1. Addressing shortcomings identified. 2. Reforms to be brought with regard to the procedures for the placement of minors in residential institutions / shelters for children. And 3. The management of residential institutions / shelters for children. Mr. Deputy Speaker, sir, I wish to inform the House that the report of the Fact-Finding Committee is being presently examined and consideration will be given to the recommendations or even the report itself being released in due course.
Just one last question.
Je vous remercie, Monsieur le Vice-président. Would the Minister inform the House what measures have been implemented so far based on the recommendation of the Fact-Finding Committee? Thank you.
As I informed the House, the report is still being under consideration and further actions will be taken in due course.
Thank you. Honourable members, the table has been advised that the following PQs have been withdrawn. B243, B247, B259, B260, B264, B265, B262, B257, B263, B254, B256, B246, B249, B251, B237, B252, B258, B266, B238, B245, B250, B255, B240, sorry, B242, and B248. Time is over. The Honourable Madam Speaker will take the chair.
Thank you, Deputy Speaker.
Motion.
Yes, Honourable Prime Minister.
Madam Speaker, I beg to move that all the business on today's order paper be exempted for the provisions of paragraph 2 of Standing Order 10.
Yes. The question is that all the business on today's order paper be exempted from the provisions of paragraph 2 of Standing Order 10. Those in favour say aye. Those against say no. The ayes have it.
Statement by Ministers, none. Public bills, first reading.
Madam Speaker, I move that the Public Inquiries Bill number 5 of 2025 be read a first time.
Yes, the motion needs to be seconded. Thank you, Deputy Prime Minister.
Public bills, second reading.
Speaker, I move that the Bail Amendment Bill number 3 of 2025 be read a second time.
Yes.
Madam Speaker, the term bail is a common term that is frequently used in our legal jargon, and I presume in other jurisdictions also. However, the term bail remains an undefined term in our law books. It is not even defined under the Bail Act of 1999, which is the main legislation that deals with bail. Even in the Constitution, the term bail is not defined, nor is the term bail used, other than under Section 53A, which has anyway been declared unconstitutional. However, Madam Speaker, the alternative term used in the supreme law of this country is liberty. In the law book Release on Bail, Law and Practice, written by one D.C. Pandey from India, it is mentioned under Chapter 2 thereof, and I quote, "The dictionary meaning of the expression bail denotes a security for appearance of a prisoner for his release." Etymologically, the word is derived from an old French verb, bail, which means to give or to deliver, although another view is that its derivation is from Latin term baiulare, meaning to bear a burden, unquote. Just like we all baiulare the previous government. It goes further on to state, and I quote, that the intent of the arrest being only to compel an appearance in court at the return of the writ. That purpose is equally unanswered whether the sheriff detains his person or takes sufficient security for his appearance, called bail, because the defendant is bailed or delivered to his sureties upon their giving security for his appearance, unquote. Bail is accordingly, Madam Speaker, a conditional liberty, and the right to personal liberty is a fundamental right that is enshrined in our Constitution under Section 5 thereof. Bail thus stands at the crossroads of liberty and security between the presumption of innocence and the imperative of justice. However, Madam Speaker, in lieu of upholding this fundamental right of a citizen to be at liberty, this House will recall that in the not-so-past, the then Commissioner of Police disagreed on many occasions with the advice of the Director of Public Prosecutions not to object to the release on bail of several defendants. This situation even led to the Commissioner of Police lodging a plaint before the Supreme Court, the Commissioner of Police versus the Director of Public Prosecutions, SCR number 124745, for constitutional relief pursuant to Section 83, challenging the powers of the DPP with regards to inter alia bail proceedings at investigation stage. Madam Speaker, since the institution of this new government, this House will certainly agree that this conflict has subsided, but to avoid any such conflict occurring again in the future, this bill is being proposed as to amend the Bail Act with a view to delimiting the respective powers of the DPP and those of the CP with regards to matters pertaining to the release on bail of a defendant or detainee, and with a view to bringing about certainty in this area of the law. Madam Speaker, let me now explain to the House how this uncertainty arose. As per Section 44B of the Bail Act, it provides that where immediately after ordering the release of a defendant, or detainee, the magistrate is notified by the DPP that an application to set aside his decision is being made before the Supreme Court and that a stay of execution is required, the magistrate shall stay execution of the order and remand defendant or detainee until the Supreme Court determines the application. In other words, Madam Speaker, only the DPP and not the Commissioner of Police has the power to move for a stay of the decision of the magistrate. However, and most surprisingly, Section 44B of the Bail Act further provides that where a magistrate has ordered the release on bail of a defendant or detainee, both the DPP and the Commissioner of Police have the power to make an application before the Supreme Court to set aside the decision to release the defendant or detainee on bail. These aforementioned provisions are not in consonant with each other, as on the one hand, it is only the DPP who has the power to move for a stay of execution of the decision of a magistrate to release a defendant or detainee on bail, while on the other hand, both the DPP and the Commissioner of Police have the power to make an application to the Supreme Court to set aside a decision of a magistrate to release a defendant or detainee on bail. This is absurd, Madam Speaker. If you do not have the power to move for a stay of execution of the decision of a magistrate, which power is conferred precisely to make an application to the Supreme Court to set aside the decision of the magistrate, how can you, when not having the power to move for a stay of execution of the decision of the magistrate, have the power to make an application to the Supreme Court? In fact, this uncertainty in the law has created this situation of conflict. The more so that two authorities cannot have the same powers. I have perused the Hansard debates of the Bail Bill of 1999, and astonishingly, the Bail Bill which was debated in this Assembly did not contain the provisions that I mentioned earlier. In fact, Madam Speaker, these provisions were introduced at committee stage of that bill. Maybe, and I say maybe, when amending the Bail Bill of 1999 at committee stage, a mistake in the drafting of the new provisions may have been made, thus creating that uncertainty in the law. Moreover, the current law grants parallel authority to both Director of Public Prosecutions and the Commissioner of Police to object to bail. The intention was never to create conflict, but to ensure continuity. Therefore, in the absence of the DPP's representative, the police could object to bail based on factual concerns. The DPP, upon reviewing the case and preparing for the hearing, would determine whether the objection was legally justified. If the DPP disagreed, the objection would be withdrawn and the police would abide by this decision. However, recent practice has deviated from this. The then Commissioner of Police has claimed the power to persist in objecting to bail. And even when the DPP, constitutionally entrusted with prosecutorial oversight, considered that there was no legal basis for such opposition. Worse still, the Commissioner of Police engaged the services of lawyers in the private practice to argue that the DPP, cases that the DPP found untenable. This encroachment blurred the lines between investigation and prosecution, two distinct functions assigned by the Constitution to two separate authorities. It led to a toxic situation, one where the police and the apex prosecuting authority were in open conflict, forced into lawsuits against each other, one where public trust in the justice system eroded, as citizens questioned whose orders the police were truly following, one where suspicions of political interference in the detention of citizens became all too justified. With a view to therefore addressing these issues, this bill reinstates the primacy of the DPP in prosecutorial decision-making, ensuring that bail objections are legally sound, free from undue influence, and consistent with the rule of law. Madam Speaker, a magistrate's ruling on bail depends on the objections raised by the prosecution. These objections must be grounded in facts, facts best known to the police. Whether an accused has strong family ties that mitigate the risk of evading justice, whether key witnesses remain to be interviewed and need to be protected from interference. These are factual considerations for the police to highlight. As such, Clause 4 of the bill provides that the Commissioner of Police will have the sole discretion not to object to the release on bail of a defendant or detainee before a court. However, where an application is made before a court for the release on bail of a defendant or detainee, and the Commissioner of Police has the intention to object to such release, he shall seek the advice of the Director of Public Prosecutions thereon, and the decision to object or not to object to such release shall rest solely on the DPP. The reasoning to give the DPP that sole discretion is because denying bail is a question of law, one that falls within the competence of the DPP only. Clause 6, Madam Speaker. Clause 6 of the bill further provides that where a magistrate orders the release on bail of a defendant or detainee, the power to apply to the Supreme Court for an order setting aside the determination of the magistrate to release the defendant or detainee on bail shall henceforth rest solely on the DPP in lieu and instead of both the DPP and the Commissioner of Police. In addition, it has been provided in Clause 6 of the bill that where the DPP fails to apply to the Supreme Court for an order setting aside the determination of the magistrate to release a defendant or detainee on bail, not later than 7 days after such an order, the defendant or detainee who had been remanded to custody must on the next day following the expiry of the 7-day period be brought before the court, who shall thereupon release him on bail as originally ordered by the court. Opportunity has also been taken, Madam Speaker, in Clause 3 of the bill to redefine the term detainee, and in Clause 5 of the bill to clarify some bail-related provisions. I wish to inform the House that the office of the DPP and the DPP have been consulted, and he has no objection to the amendments being proposed to the Bail Act. Madam Speaker, I am being tasked, in the absence of my good friend, the Honourable Member, the Attorney-General, who is not present, who is unable to come here today, with pronouncing this speech. And I'd like to...
I was actually thinking, I'm sorry, Minister,
Yes.
May I just say a word?
Yes.
I was actually thinking maybe it's important for the record that you should say that you are now acting Attorney General, and it is in that capacity that you're making this speech and that you're going to run through the bill. Thank you. Carry on, please.
This is precisely what I was about to say at
yes.
this juncture. Yes, this is what I was saying. This is what I was about to say now, and this is why I took note here. I'd said I'm being tasked with having to pronounce this speech today in the National Assembly as acting Attorney General. My good friend, the Honourable Attorney-General, cannot attend the National Assembly today, and I have spoken to him just before pronouncing the speech and sought further instructions from him. And I'd like to not only thank him, but also thank all the officers at the Attorney General's office and those who have drafted this bill, who have done an excellent job. And I also thank them for having briefed me in the absence of my, I would say to a senior counsel, my lineage senior, for pronouncing this speech and presenting this bill to the Assembly. So if I may now go on, the bail is not merely a procedural matter, Madam Speaker. It is a constitutional and societal issue. The right to liberty is sacred, but so too is public confidence in our justice system. This bill reaffirms a fundamental principle, that is, the administration of justice must be guided by law, not convenience, and certainly not political influence. The bail amendment bill before the House brings much needed clarity to a legal framework that in recent times has been clouded by uncertainty and exploited for political ends. Like the recent amendments to the Financial Crimes Commission Act, this bill restores clarity, fairness, and the rule of law. It ensures that decisions on bail are made by those constitutionally entrusted to do so, and that the balance between individual freedom and the pursuit of justice is upheld. With these words, Madam Speaker, I commend this bill to the House.
Yes, who's seconding? Yes. Yes. Honourable Minister, yes.
Thank you, Madam the Speaker. Madam the Speaker, I will be very short since we are dealing with a few amendments to the Bail Act. But I should say this, that although the amendments are few, but they go a long way in showing our determination and our commitment to enhance transparency in the decision-making process of our institutions, and also in reinforcing the powers and the independence of our institutions. And of course, today we are talking about the powers of the police, also the Deputy Prime Minister, have been working so hard, bringing amendments before this House to restore the image of our institution. Our institutions, we are talking about institutions having constitutional status, not parastatal bodies, not institutions under ministry, but we are talking here about very important institutions which are in our constitution. And the population has witnessed that as soon as we have come in power, the Prime Minister has brought in very important amendments in order to restore the image of these institutions. Madam the Speaker, this Parliament is a vivid example. Your nomination as Speaker, you are shining in the chair, Madam the Speaker. And votre rayonnement est en train d'éclairer les débats dans cette chambre. And you just for 1 minute, just compare. I was in this house. Just for 1 minute. Just compare how the debates are going on now and compare it to the 10 last years. But sometimes it's good. I know in the previous debates, orators have been speaking about it, but it's important that we repeat it and repeat it again. Because we don't want this to happen again to our democracy. Récemment, là, on a apporté les amendements. The Financial Crime Commission Amendment Bill was introduced. Once again, in order to bring transparency, afin de restaurer la crédibilité et l'indépendance du DPP on cases with regards to corruption and anti-money laundering. Madame la Présidente, il y a plusieurs exemples where this government has had to intervene, as I've said, in a very short span of time to bring in corrective measures. The police force is another example. Qu'est-ce qu'on n'a pas vu? Qu'est-ce qu'on n'a pas témoigné sous l'ancien régime par rapport au commissaire de police? Today, we have a new commissioner who is rebuilding the trust of the people in the police force. Never in the history of our country have we witnessed our institutions being so undermined, their image tarnished by a government, as has been the case over the past 10 years. And as I've said, and I repeat it because it is important that people know, we are not talking about minor institutions. We are talking about very important institutions that have constitutional status. Madame la Présidente, when the drafters of our constitution, our past political leaders, they were sitting in Lancaster House trying to bring in propositions to consolidate our constitution. Mettez des garde-fous so that they can secure the independence of our institution. There was a reason behind that. Because they wanted that the population should have trust in our constitution. The population should have trust in our institutions. These were the reasons why. They had imposed garde-fou. They wanted that the institutions not only operate in independence, but also seen to be operating in independence. Madame la Présidente, on parlait à cette époque, if you go through the procès verbal de ces comités, you will see that they were even talking about, at that time, the Queen appointing the Commissioner of Police. Because they wanted that these institutions should have the independence that is required, so that the people can trust these institutions. Mais malheureusement, sous l'ancien régime, ça n'a pas été le cas. Pour commencer, by starting from the top, la présidence, Madame la Présidente, la présidence, there was a mistrust between the President at that time and the Prime Minister. L'affaire Sobrino. La Présidente de la République a même institué une commission d'enquête ratée, without consultation from the cabinet of ministers. Et puis ça, elle s'est retrouvée elle-même face à une commission d'enquête. And so there was that mistrust between the two institutions, and c'est comique, mais we could have ended up in an institutional clash between two very high institutions in our constitution, la Présidente de la République et le bureau du Premier ministre. Vous imaginez? There was also the Commissioner of Police. You remember? The Commissioner of Police was placed on probation. Even the head of the CID, he also was on contract. And they were being used to arrest political opponents. Madam the Speaker, there was also the recommendation of the Commission on the Prerogative of Mercy. I remember the case of the son of the former Commissioner of Police, wiping out a conviction of 12-month imprisonment without any reasons and in total opacity. This is how our institutions were functioning at that time. The political appointment of political agents and the Electoral Supervisory Commission and the Electoral Boundaries Commission shows a blatant disrespect that the previous government had to the independence of these constitutional creatures. Madame la Présidente, with regard to this
bill
act, similarly, back in 1999, the Labour Party had brought a new bail act, right? And they made, when the act was passed, the idea was to make the granting of bail the rule and the objecting to bail the exception. But again, little did we know that we would have a former Commissioner of Police who would usurp the powers of the DPP and refuse bail, as explained by the acting Attorney-General, in cases where there were political opponents. And this even resulted in an institutional clash between the police, the Commissioner of Police, and the DPP's office, resulting in court cases before our courts of law. And this is why, Madam the Speaker, we are having to intervene today, once again, in order to bring back trust in our Constitution, in our institutions that have constitutional status, by defining with clarity the powers of the Commissioner of Police and the powers of the DPP when it comes to bail applications. Thank you.
Thank you so much. Yes, Honourable Junior Minister.
Merci, Madame la Présidente.
Junior Minister, if I may, try and speak a bit about the bill, please.
Okay, fine. Madame la Présidente, comme les deux honorables ministres qui m'ont précédé, je ne suis ni avocate et je n'ai aucune bagage juridique. Je m'adresse à cette auguste Assemblée sur le Bail Amendment Bill en étant qu'une citoyenne concernée et engagée avec ce présent gouvernement pour promouvoir l'espace démocratique dans le respect de la Constitution et de notre État de droit. Madame la Présidente, je constate que l'honorable Adrien Duval du PMSD et l'honorable leader de l'opposition ne se sont pas engagés à prendre la parole sur cet important projet de loi. Je comprends que le MSM ne participe pas car durant le parcours de ces 10 dernières années, ils ont torpillé le bureau du DPP. Mais l'honorable Adrien Duval et le PMSD ne participent pas. C'est la preuve de ce qui est devenu et de ce qui reste du PMSD en termes de respect et d'importance accordée au mot démocratie et du bureau du DPP. Madame la Présidente, notre pays a traversé une grave crise institutionnelle. Nos institutions étaient gangrénées, pourries par le gouvernement MSM sans scrupules, avec la complicité d'un commissaire de police corrompu qui a abusé de ses pouvoirs pour des fins politiques. Ce commissaire n'était rien d'autre qu'une marionnette entre les mains du couple Jugnut, dont la toxicité a empoisonné nos institutions. Madame la Présidente, dans cette force policière, la compétence, l'expérience n'étaient plus critères de promotion. Ce qu'il fallait, tout simplement, participer dans des cover-up ou simplement une simple application de gel. C'est écœurant, dégradant et tout simplement honteux, Madame la Présidente. La police qui censé nous protéger était devenu un motif de peur. Poursuites fabriquées, planting, arrestations sélectives, abus du recours aux charges provisoires, un climat d'oppression s'est installé. Et nous en avons été profondément choqués d'apprendre qu'il existait dans nos rangs des policiers tortionnaires, Madame la Présidente, oui, tortionnaires. Ceux qui ont torturé, humilié des prisonniers en utilisant des tasers sur leur partie intime. Ce sont des actes inhumains. Et j'espère sincèrement qu'ils paieront très bientôt pour leurs crimes, Madame la Présidente. Notre pays était devenu un véritable État policier, au service d'une police politique dirigée par le MSM. Madame la Présidente, dans tout cela, notre seul rempart était et reste le judiciaire. Heureusement, 2 femmes magistrates qui ont su redonner espoir à notre système judiciaire. Face aux pressions politiques, elles ont tenu bon. Avec conviction, je parle là des cas Kisnen et de Bruno Lorette. Madam Speaker, we must also reflect on the disgraceful and unprecedented attack on judicial independence made by the former Prime Minister, who had the audacity to call a court ruling, and I quote, un gisement bancal. This shocking statement exposed the MSM utter disregard for the judiciary. It is disgraceful coming from a so-called lawyer. Today, in stark contrast, the current Prime Minister and Deputy Prime Minister have given a lesson in governance by not interfering in his case when he was arrested by the FCC, even when the public will wanted to see him behind the bars. Madame la Présidente, regardons dans le rétroviseur. Le MSM a toujours voulu contrôler le DPP. Souvenons-nous de la fameuse Prosecution Commission en 2016 qui a mené à la démission du PMSD grâce à des experts en droit qui ont su éclairer son leader sur les dangers de cette loi. Je tiens à remercier chaleureusement l'un d'entre eux qui, bien en n'étant même pas membre du PMSD, a agi par conviction profonde pour la démocratie et l'indépendance judiciaire. C'est l'honorable Kuchal Lobin. Madame la Présidente, je saisis cette occasion pour saluer l'honorable Adrien Duval, qui fut le premier à démissionner à cause de cette dérive. Mais hélas, quelques années plus tard, il a oublié son combat et s'est précipité, aveuglé par le pouvoir ou peut-être l'argent, pour aller s'asseoir sur la chaise du speaker, du loud speaker. Le pauvre lui-même ne savait pas qu'il a été démissionné par le Premier ministre. Putting my son first, telle a toujours été la devise du leader du PMSD. C'est pour cela qu'il est le seul à avoir échappé à la colère populaire. En sacrifiant des piliers comme Oro Perro, qui a tant travaillé dans la circonscription numéro 4, et bien d'autres compagnons jetés comme des pions, comme on dit en créole, dans Carocan. Je suis fière d'avoir été la première à quitter ce parti et fière aussi de l'honorable Richard Duval et de l'honorable Kuchal Lobin qui ont eux aussi quitté ce navire pour fonder ensemble avec d'autres amis les Nouveaux démocrates, un parti d'avenir. Madame la Présidente, je félicite notre Attorney-General. Depuis sa nomination, il n'a pas eu un jour de répit. Il a travaillé sans relâche sur plusieurs amendements pour restaurer la démocratie et redonner son indépendance au judiciaire et au DPP. Je sais qu'il n'a pas eu le luxe de déguster du sanglier ou de shipper un blue au Stack Party comme son prédécesseur. Madam Speaker, I would like to express my strong support to the Bail Amendment Bill, a crucial legislative reform brought forward by this government. This bill ensures that the DPP alone has the final say on the prosecution matters, free from any interference. It removes the Commissioner of Police abilities independently object to bail, making it crystal clear that only the DPP can challenge a bail decision before the Supreme Court. With this bill, we send an unmistakable message. Never again will a government be able to manipulate the DPP's office for political ends. Never again will the police be turned into a political weapon. Never again will the judiciary be undermined for the sake of power. Madame la Présidente, notre pays a traversé une grave crise institutionnelle. Nos institutions ont été engrenées, comme je vous ai dit, mais grâce à cet amendement, aujourd'hui, on va retrouver la liberté et l'indépendance de notre système judiciaire. To conclude, Madam Speaker, I would like to quote George Herbert, "Where there is a will, there is a way." Madam Speaker, today, in this House, we have the will, we have the competence, we have the motivation, the quality, and the quantity. And under the guidance of our Prime Minister and Deputy Prime Minister, we are on the right path to make Mauritius be Mauritius again. Thank you, Madam Speaker.
Honourable Junior Minister, thank you. I would like you to be careful and perhaps withdraw one part of your speech, because you're talking about Honourable Duval, who maybe is not present, but he's a member of the House. And I don't think you're allowed to impute motives when you said that part, that maybe, you know what I mean, maybe he did it for money. That would be imputing motives. We don't want to open a debate later on this issue. If you would please kindly withdraw that part.
I will do it, Madam Speaker.
Thank you. Yes, now I have Mr. Babula.
Thank you, Madam Speaker. The Bail Amendment Bill is indeed clarifying the powers of the DPP and the Commissioner of Police. Madam Speaker, the Republic of Mauritius is a democratic state, and the Constitution is the supreme law. The Constitution guarantees our fundamental rights and freedom of the individual. Section 5 of the Constitution embodies the protection of right and personal liberty. Madam Speaker, the right to liberty of an individual is enshrined in Section 5.3 of our Constitution and is reflected in Section 3 of the Bail Act 1999, which provides that notwithstanding any other enactment and subject to Section 4, every defendant or detainee shall be entitled to be released on bail. In considering any application, the learned magistrate bears in mind the fundamental constitutional principle that freedom is the rule and detention on account of reasonable suspicion the exception, and must see to it that bail is not being withheld as a form of punishment. Madam Speaker, on the other hand, the Director of Public Prosecutions derive his powers under Section 72 of the Constitution. Section 72(6) states that in the exercise of the powers conferred upon him by this section, the DPP shall not be subject to the direction or control of any other person or authority, whereas the Commissioner of Police powers are vested in him by Section 71 of the Constitution. Madam Speaker, this bill presented by the Honourable Attorney-General is a clear sign that the liberty of the people that they voted for on the 10th of November 2024 will always be respected. And this government is doing its best to restore democracy. Madam Speaker, the previous government was a fake one. We had a fake Prime Minister, a fake Speaker, and not forgetting the fake Commissioner of Police, where power was abused upon the citizens of this country. People were scared because the kitchen could strike at any time with his striking team. And even when the judiciary were protecting the rights of the citizens, as per the Constitution and the laws of this land, all kinds of loopholes were circumvented to oppress people and control their liberty. One of them is the Bail Act, as rightly pointed out by the Honourable Acting Attorney-General, Section 4B, 4A of the Bail Act. Previously, this was not the case. This law has been here since long, but all has started when the Commissioner of Police want to control everything. Madam Speaker, the case of Bruno Lorette is a clear-cut case to explain how the CP wanted to control everything. Honourable Minister Shakil Mohammed, who is presenting the bill today, was his barrister. He stated at that time, le commissaire de police n'a pas le locus standi, selon la loi pour entrer une telle action. That was at that time. Madam Speaker, the Commissioner of Police wanted to attempt a kind of constitutional revolution that would make the CP the one who would hold the power of release to or detain a suspect alone. The case of Akil Bisesar. This explains why this bill is necessary. What happened in the case of Akil Bisesar? He was arrested by the striking team. He was presented before a court of law. His counsel put a motion for his release on bail. And the Commissioner of Police asked for the DPP to be present on that day. And when the state law officer was present on that day, he stated that there was no objection for his release. And what happened? This is on that day, Madam Speaker, the fake government and the fake Commissioner of Police was not happy. They had to do everything in their capacity to prevent this release. Everything was done to please Pinocchio because he nominates the CP. Madam Speaker, this has never happened before in Mauritius in any court of law. Nor did the police prosecutor say a word. But what happened? The Superintendent of Police, Mr. Gangadin, made the following statement on the floor of the court. He states, the CP is abroad in France, and prior from leaving the country on Saturday, he was formally instructed to attend court today in virtue of the constitutional powers vested upon him. He has instructed me that if the DPP goes against police instruction, then for the police to object and mention his stand, that if he need be, the office of the CP will solicit help from outside of the DPP's office. He states that this is interference of the DPP. And guess on whom the Commissioner of Police placed his bet in this case? Is none other than Mr. Yerigadou, who knows how to play, and Mrs. Sonauri, the Prime Minister's attorney, looting again the taxpayers' money from the back door. The Commissioner of Police feel aggrieved in the manner in which the DPP appears to have usurped the CP's power, which was never his power in any way. He filed 6 grounds before the Supreme Court. All these grounds failed, Madam Speaker, on the preliminary objections raised by the counsel for Mr. Akil Bisesar. The powers in relation to the Supreme Court, Madam Speaker, in relation to the case of Rangasamy and the DPP, the full bench of the Supreme Court considered the jurisdictional basis to review any decision of any subordinate court in criminal matters. It is right law that a review envisaged under the Section 44A of the Bail Act and Section 82(1) of the Constitution entails a re-hearing of the Supreme Court. even though in the case of BCSR, there was no ruling, still the Machiavellic team tried to challenge the learned magistrate and the DPP. Madam Speaker, the fake CP was willing to improvise a disguised way of challenging the constitutional powers of that the DPP holds, and wanted to hold the power to arrest, release, and detain a suspect. Now the amendment bill will amend the Bail Act so as to delimit the respective powers of the DPP and those of the Commissioner of Police. Madam Speaker, the DPP will be the only one to decide whether to object or not for the release of a detainee, and also the power to apply to the Supreme Court for an order setting aside the determination of the magistrate to the release of the detainee on bail. This government will make sure that the rights and freedom of the citizens are respected and the rule of law prevails, and where the DPP will continue to enjoy the constitutional powers entrusted to him as guaranteed by the Constitution. I commend the bill to the House, Madam Speaker. Thank you.
Thank you. Yes. Ms. Béranger? No? You want a break? Okay. I'm so sorry. I am in the hands of everybody. I think everybody wants to go for tea. Let's break. Vous ne perdez rien à attendre. Okay, let us break. On aurait pu la laisser. Hein? Yes, 30 minutes. Yes, we have, can we carry on, Ms. Béranger?
Madame Speaker, laisse-moi commencer par dire qu'ils m'ont accueilli positivement, ça posé la loi là, Bill Amendment Bill. Le gouvernement a raison pour venir clarifier le rôle directeur poursuite publique, DPP, et le rôle de la police concernant caution. Il y a une réforme qui est nécessaire.
Don't go too long in Creole. You know I'm in favor, but according to standing orders, we have to use English and French. I'm not stopping you for good, but I do appreciate your using Creole, but we are not, strictly speaking, allowed to use Creole.
Madame la Présidente, je comprends les contraintes et je suis disposée à donner une copie de mon discours au Hansard Unit s'il le faut.
Non, non. Je ne peux pas vous laisser parler, dire votre discours en entier en créole pour le moment. Ça va venir.
Madame la Présidente, c'est tant mieux si l'on veut adapter la technologie et les compétences, si l'on veut consacrer le créole mauricien dans nos lois. Mais comme je l'ai expliqué la dernière fois, rien ne nous empêche aujourd'hui de donner une lecture plus démocratique à notre Constitution dès maintenant, sans attendre la création des comités.
Je ne peux pas être d'accord avec vous.
Je respecte votre décision, mais dans ces conditions,
non, mais je tiens compte de ce que vous dites.
Dans ces conditions, je n'ai pas d'autre choix, Madame la Présidente. Mon discours sera, comme le créole mauricien aujourd'hui, réduit au silence.
Too bad. Monsieur Sibon.
Thank you, Madam the Speaker. Madam the Speaker, let me first thank the Honourable Attorney-General for working relentlessly and coming forward with this amendment to the Bail Act that will bring certainty to this area of the law. This government is leading the fight to build a fairer and more equitable justice system. The previous government has aimed to circumvent the powers of the Office of the Director of Public Prosecutions when they allowed the Commissioner of Police to challenge the constitutional powers of the DPP, something that never happened before. Madam the Speaker, the amendment to the Bail Act is to consolidate and restore the powers of the DPP that was originally vested with. Our Prime Minister, Dr. Navin Ramgoolam, rightly said that we are at a defining moment in the history of our country, moving towards a total reconstruction of our nation and foster a system with an inclusive society where unity and justice will prevail. Madam the Speaker, the existing conflict between the Commissioner of Police and the Office of the DPP, our fundamental right of liberty guaranteed under the Constitution is at stake. And as we know, the rationale behind the Bail Act is to ensure that liberty is the rule and deprivation of liberty on the grounds of objection is merely an exception. Time and again, this has been emphasized by the courts of law in Mauritius and by the Judicial Committee of the Privy Council, where its decision is grounded in our Constitution, being the final court of appeal. Madam the Speaker, it is Section 72 of the Constitution that establishes and sets out the powers of the DPP, where the DPP has the power to institute and undertake all criminal proceedings before a court of law. And the DPP is further empowered to take over and continue any such criminal proceedings that may have been instituted by another person, or to discontinue any such proceedings at any stage before judgment is delivered. Madam the Speaker, Section 10, subsection 6 of our Constitution secures a constitutional guarantee of the independence of the DPP to exercise its powers free from the direction, no control of any other person. This further enriches the principles of separation of powers embodied in our Constitution. The integrity of the judicial process with the powers of the DPP would be compromised should the police be allowed to object bail applications without the DPP's consent. Madam the Speaker, the Commissioner of Police already has a huge responsibility for overseeing its operations and ensuring the effective enforcement of laws that are implemented for the safety and security of the community. They must further demonstrate that they are applying the law fairly and operate with transparency. Madam the Speaker, we recently felt the troubling times the country went through with the disturbing turn of conflict between the office of the DPP and that of the Commissioner of Police, who opposed the decision of the DPP, who decided not to challenge the ruling of the senior magistrate at the Muka District Court in the case of one, Mr. B.L., who was granted bail, and again in another case of lawyer, Mr. A.B., where the office of the DPP stood up not to object to his bail application. This confrontation between the important organs of the state became public when we saw the head of a constitutional post, being the Commissioner of Police, who came out publicly against another head of constitutional post, thus putting in serious doubt of its legal judgment. Madam the Speaker, I am sure that when the father of our nation, late Sasiu Sagar Ramgulam, who campaigned for our independence 57 years back and negotiated and approved the Constitution that time, the prominent question in his mind would have been to ensure that a proper set of checks and balances are upheld so that our young generation and the people of Mauritius do not feel threatened by a single police force. And those checks and balances were indeed specified in our Constitution, that time to ensure that the constitutional powers are granted to the DPP in all matters of prosecution. Madam the Speaker, to preserve the integrity of our institution, it is not a good practice for the Commissioner of Police to initiate private prosecution and to bypass the constitutional prerogatives of the DPP in prosecution matters, when in fact both institutions were intended to collaborate and avoid conflict to meet the end of justice in our democratic society. Madam the Speaker, it is highly essential to bring clarity and delimit the respective powers of the DPP and those of the Commissioner of Police with regards to a defendant or detainee who has been provisionally charged and is awaiting bail on bail. Both the police and the office of the DPP are meant to be highly trusted, important institutions of our democratic society, where they must work together, play their independent roles, and implement their powers for good governance and for proper administration of justice, and cannot have any conflict whatsoever as they carry hopes and expectations of the people for peace and justice. Madam the Speaker, the public has entrusted this government to restore the independence of the public institutions and further to foster ethics and integrity in all walks of life, to enhance our fundamental rights, and for the DPP to prosecute offenders in the name and on behalf of the state. Under the Bail Act, it is the police who has the power to object for the release of a defendant or detainee when a provisional charge is raised. The grounds of objection raised by the police must be carefully analyzed and based on the nature of the evidence gathered to ensure that it does not violate the rights of that person established in our Constitution. The office of the DPP has expertise and is fully equipped with trained and experienced lawyers in the field to analyze the nature of the evidence gathered by the police in each and every case and to conclude whether or not an objection for release of a defendant or detainee should be raised. And each and every case must be based on its evidence and on its own merits and own facts. Madam the Speaker, the new Section 3B introduced in this bill under Section 4 of the Act rightly makes it clear that where the Commissioner of Police has the intention to object for the release of a defendant or detainee provisionally charged, he shall seek the advice of the DPP under the new law, and the decision to object shall rest solely on the DPP. Madam the Speaker, where the court has heard an application for the release on bail, after analyzing the grounds of objection raised by the police, where the court concludes and orders that the release on bail of a defendant or detainee, in such circumstances, Section 6 of the bill introduces a new Section 4A that is to be inserted in the Principal Bail Act, and again makes it very clear that the power to apply to the Supreme Court for an order to set aside the decision of the magistrate to release the defendant or detainee on bail shall rest again solely on the DPP. Madam the Speaker, to conclude, as our Prime Minister says, we have a difficult task ahead, but with this team holding experience, competence, and determination, we are confident that we shall overcome all the difficulties in building our nation and to ensure that a proper administration of justice is established to meet the ideals of the rule of law. Madam the Speaker, I welcome and support the amendments to the Bail Act introduced by the Honourable Attorney-General, as this clarifies the powers and integrity of both institutions. I thank you all for your attention and commitment for a better Mauritius.
Honourable members, after having ruled out Honourable Junior Minister Béranger, I would like to refer the House to Standing Order 5 so that you understand why I had to take this stand. It's nothing personal, of course, and everybody knows my personal stand on the issue of introducing Creole in the National Assembly. It is not just a question of technique or technicity. Standing Order 5 says, the proceedings and debates of the Assembly shall be in the English language, but a member may address the Assembly in French. I don't think there is any doubt on the fact that this is the way that it is for the moment. Honourable Prime Minister, may I seize this opportunity to tell you that maybe you can think about whether we should not have a select committee on the question of introducing Creole in the Assembly. I have no doubt that most members will probably support this, but there are things to be discussed, including the amendment of the standing orders. And as we told the House the other day, we have lots of committees, including the Standing Orders Committee, which will have to sit, and maybe amongst the issues to be discussed will be the issue of language. If you wish to start again, Ms. Béranger, you may do so now, but I will respect your choice. Okay. Honourable Ramdas.
Merci, Madame la Présidente. Madame la Présidente, d'abord, permettez-moi de commencer par saluer tout bas et remercier l'Honorable Attorney-General ainsi que l'Honorable Ministre des Terres et du Logement pour avoir présenté en toute urgence à l'Assemblée ce projet de loi. Un projet de loi qui traite la question des limites du pouvoir du directeur des poursuites publiques d'une part et des pouvoirs du commissaire de police de l'autre quant au droit de l'individu, quant au droit fondamental à la liberté de l'individu, et cela dans le contexte spécifique du Bail Act. Madame la Présidente, la gravité de cette question et l'urgence de la situation se reflètent précisément dans la crise institutionnelle dont faisait face notre démocratie sous le précédent gouvernement. Effectivement, c'était bien une première pour notre pays de voir deux institutions constitutionnelles clés, notamment deux institutions constitutionnelles clés de notre système de justice, notamment le directeur des poursuites publiques et le commissaire de police, impliqués dans une bataille juridique sans précédent. Une bataille juridique effectivement sans précédent sur la limite de leurs pouvoirs, de leurs attributs respectifs. Et cela en ce qui concerne la remise en liberté d'un suspect en attendant l'issue d'une enquête. Et cette bataille juridique, Madame la Présidente, a, dites-vous bien, coûté pas moins de 14 millions de roupies à l'État mauricien. Il y a quelques semaines de cela, nous avons entendu la réponse du Premier ministre suite à une question qui lui avait été posée par rapport aux dépenses encourues et en termes de frais légaux et de conseils juridiques retenus par l'ancien commissaire de police, et nous avons appris que la somme de 14 millions de roupies a été dépensée pour cette bataille juridique. Et il est malheureux, Madame la Présidente, que le peuple mauricien fasse les frais d'une question d'ego de la part de l'ancien commissaire de police, celui qui agissait, selon toute évidence, clairement sur les instructions de la cuisine. Et rappelons-le, Madame la Présidente, la source même de cette tension institutionnelle était la décision du bureau du directeur des poursuites publiques de ne pas soutenir, mais surtout, ou plutôt, de se poser à une contestation du commissaire de police de l'ordre de la Cour autorisant la remise en liberté conditionnelle de plusieurs individus, dont M. Bruno Lorette, Maître Akil Bissessa, Chéri Singh, Vimen Sapapati, entre autres. Et nous avons par la suite appris, Madame la Présidente, que les charges provisoires pesant sur plusieurs de ces personnes, dont je viens de vous citer, ont été purement et simplement rayées. Et nous avons aussi appris qu'une ancienne membre de la force policière, une certaine WPC Goumani, avait pris les devants il n'y a pas longtemps pour rapporter un cas possible de planting of evidence dans le cas de Vimen Sabapati. Imaginons, Madame la Présidente, ces nouveaux faits, en fait, nous poussent à nous interroger si cela aurait fait honneur à notre système de justice et notre identité comme une démocratie si ces personnes avaient été reconduites en cellules policières, si ces personnes avaient été privées de leur liberté, si le DPP avait capitulé sous l'insistance du commissaire de police d'alors de continuer à objecter à leur remise en liberté. Madam Speaker, this bill could not have been presented to this Assembly at a more appropriate time. In fact, it addresses a core issue, an issue that strikes at the very heart of our democratic values and the rule of law. It relates, in fact, to the importance of giving to the Director of Public Prosecutions, the DPP, clear and unfettered powers to prosecute and also with a view to promote the sacrosanct principle of the presumption of innocence in criminal proceedings. In order to properly understand the importance of this bill, Madame la Présidente, we must first examine the constitutional provisions, its historical context, and its present implications. One must understand, Madam Speaker, that the independence of the DPP is not only vital for justice, but it's crucial for the very survival of our democratic institutions. The role of the DPP in Mauritius, as set out under Section 72 of our Constitution, confers upon him the power to initiate, control, and discontinue criminal proceedings. Now, Madam Speaker, with the adoption of the present Bail Act, back in the year 1999, the presumption in favor of bail was given a statutory footing under Section 3 of the Act. In fact, Section 3 provided that every defendant or detainee shall be entitled to be released on bail subject to Section 4. And Section 4 of the Act provided exhaustively the grounds on which a court may refuse to release on bail a defendant or a detainee. Now, one major shortcoming in the Act, which is precisely what is sought to be curbed, what is sought to be corrected under the present amendment, was that it did not clearly specify which entity between the Commission of Police and that of the DPP was vested with clear powers to decide whether or not to object to the release on bail of a defendant or detainee. And quite regrettably, Madam Speaker, this important shortcoming allowed for a tension to creep into the rapport between the Commission of Police and the Director of Public Prosecution, as Section 4, subsection 4 of the Act referred fleetingly to an objection to bail formulated either by the Commission of Police or the Director of Public Prosecution. But it did not, unfortunately, cater for any situation where there is a conflict, there is a divergence of opinion between those two posts as to whether or not a defendant or detainee ought to be released on bail. Et bien évidemment, Madame la Présidente, cette incertitude, cette lacune dans nos lois a été utilisée tout naturellement par le MSM, fidèle à son habitude, à travers l'ancien commissaire de police, à des fins politiques, afin de satisfaire un agenda politique et dans l'unique but de persécuter ses adversaires politiques. In fact, when a political party controls the prosecution process, Madam Speaker, there is danger. There is danger. Danger that the justice system will be used as a tool for retribution. Danger of a loss of trust in the legal system, leading to an erosion of our democratic values. And it is precisely the mandate of this newly elected government, Madam Speaker, to consolidate our constitutional and democratic values already embodied in our government program. And justice cannot, Madam Speaker, be impartial if those in power can manipulate it for their own political advantage. And this is why this is in fact precisely why an independent judiciary, and by extension, an independent Director of Public Prosecution, is essential for the protection of human rights and the rule of law. This bill, Madam Speaker, provides that where the Commissioner of Police intends to object to the release of bail of a defendant or detainee, he will now be under an obligation to seek the legal advice of the Director of Public Prosecution and will be bound by such advice and decision of the DPP. And by adopting this mechanism, Madam Speaker, the Bail Amendment Bill seeks to grant a prerogative to the DPP, who, unlike the Commissioner of Police, is always required to be a person with legal training and experience as a barrister in order to be eligible for the post. And in fact, a legal background, in my very humble view, Madam Speaker, is essential to enable the decision maker, the DPP, to assess whether the exceptions to bail as set out under Section 4 of the Act can be invoked and whether such motion has a reasonable prospect of success. And this will undoubtedly, Madam Speaker, allow for an efficient allocation of resources and to present before the court only meritorious cases for a lawful restriction of a person's freedom of movement. And it is also apposite to recall that the DPP is required, Madam Speaker, to act fairly and impartially in presenting a case, and it is not the role of the DPP to secure a conviction at all cost. It is, in fact, it is my humble view, Madam Speaker, that he is a disinterested party insofar as the defendant or a detainee is concerned. And lastly, Madam Speaker, the DPP's security of tenure is akin to that of a Supreme Court judge, reinforcing the very notion that justice cannot and should not be influenced by political or external pressures. Madame la Présidente, je faillerais à mon devoir si je ne profite pas de cette occasion qui m'est accordée aujourd'hui pour exprimer quand même une certaine crainte par rapport à l'application d'un aspect de ce Bail Amendment Act. Cette loi, Madame la Présidente, si elle est votée, si elle est promulguée, et elle le sera certainement, pose quand même une certaine difficulté dont j'ai une crainte. Si elle est votée, elle aura pour conséquence qu'il y aura un nombre grandissant de dossiers qui seront référés au bureau du directeur des poursuites publiques. Et là, nous avons probablement une difficulté dans la mesure où il est impératif que ces dossiers soient traités, soient étudiés et de manière rapide et diligente, puisqu'il y va de la liberté de l'individu. Il y va de la liberté du citoyen mauricien. Donc il est impératif, Madame Speaker, que nous ne nous retrouverons pas dans une situation, et là je parle un petit peu sous la correction de mes confrères et conseillers ici présents, dont vous-même, Madame la Présidente, et on ne souhaiterait pas se retrouver dans une situation où nous sommes en cours ayant à faire face à des demandes répétitives de renvoi de la part du représentant de la poursuite sous prétexte que the stand of the DPP is not ready. C'est une phrase que nous entendons souvent en cours nécessairement, n'est-ce pas, Madame Speaker? Donc, je souhaite que le bureau du directeur des poursuites publiques fasse les arrangements nécessaires afin qu'une équipe soit dédiée justement afin de traiter ces dossiers en toute urgence et avec diligence, puisque, comme je l'ai dit, il y va de la liberté du citoyen mauricien. En guise de conclusion, Madame Speaker, if we agree that the power to prosecute must rest with an independent director of public prosecution, as the principle is enshrined under Section 72 of our Constitution, it logically follows that we should also agree that the power to object or not to object to the release on bail of a defendant ought to also rest with an independent director of public prosecution. And this is precisely why this is precisely what the bill brings about, and this is precisely why I'm supporting this bill. Thank you, Madam Speaker.
Thank you. Thank you for respecting the time. Honourable Prime Minister.
Madam Speaker, recent times have seen an unprecedented, I should say also unfortunate conflict between the Commissioner of Police and the Director of Public Prosecutions in matters of relating to bail. Of relevance, as Honourable Babulal mentioned, is the case of the Commissioner of Police against Mr. Akil Bisesar and others. The police objected to bail in that case for Mr. Bisesar, but the office of the DPP, representing the Commissioner of Police, had no objection. That should have been the end of the matter. But in spite of this, the representative of the police in court made a statement to state that the stand of the Commissioner of Police was to object to bail in the present case, in spite of what the DPP had said, and went further to say that, if need be, the office of the Commissioner of Police will solicit help from outside of the DPP's office. And in fact, the Commissioner of Police hired the services of counsel from the bar to represent the police and entered a case before the Supreme Court to quash the decision of the district magistrate. The Supreme Court refused to intervene in the matter pursuant to Section 82(1) of the Constitution. As I said, Madam Speaker, this is unprecedented. I think Honourable Babulal put his finger on it. It should never have happened. We shouldn't have had the bill today. Worse, Madam Speaker, public funds had to be dished out to various lawyers, which was totally unnecessary. Waste of public funds. Dishing out money to lawyers chosen by the Commissioner of Police, probably in court with the Prime Minister. And we don't have to guess who the lawyers, how they were chosen. From August of 2021 to November of 2024, the CP has retained the services of 5 counsels for 8 cases, including 1 King's Counsel and 1 attorney. Attorney, we all know who. The cost to the state, as you, Honourable Ramdas, just said, over 14 million rupees. Over 14 million rupees. The only objective was to undermine the professional integrity of the office of the Director of Director of Public Prosecutions, a post which is constitutional. This situation arose because, as per then the provisions of the Bail Act, namely Section 4.4 of the Bail Act, where a magistrate has ordered the release on bail of a defendant, the Commissioner of Police or the DPP may, within 7 days of the determination of the magistrate, apply to the Supreme Court to quash that, set aside the decision of the magistrate. Conflicts of such nature between law enforcement authorities undermines public confidence in our institutions and must never be allowed to happen again. Such conflict could also be due because nobody in their right mind thought that this could happen. This is why we have to come to the bill, with this bill, this amendment, to make it clear what are the provisions of the new Bail Act, especially in cases where bail is objected to, or in cases where a decision to grant bail is challenged. In order to avoid such situations from recurring, the amendment bill that is being brought to the House want to make it absolutely clear what are the powers of the Director of Public Prosecutions and what are those of the Commissioner of Police. First of all, we had to make it more crystal clear what do we mean by detainee, the definition of a detainee. Under the current law, a detainee means a person who is under arrest upon reasonable suspicion of having committed an offense. From what we see now, reasonable suspicion leaves room for interpretation, and it is a wide definition. Under this amendment bill, in order not to leave any room for doubt as who is concerned by the provisions of this Act, a detainee is defined as a person who is under arrest and is provisionally charged before a court. The ambiguity of the law, as it is, requires more clarity. And this is why, when application now, with this bill, when application for release on bail of a defendant or a detainee is refused, the court shall place on record the written reasons for its determination. Additionally, the bill provides for a situation of conflicts in relation to the release on bail of a defendant or a detainee. Accordingly, while the sole discretion not to object to bail, it will be that of the Commissioner of Police. But however, where the Commissioner of Police has the intention to object to the release on bail of a defendant or a detainee, he shall seek the advice of the DPP, and the decision not to object or not will rest solely with the Director of Public Prosecutions. More importantly, Madam Speaker, the law as it currently stands provides that when a magistrate has ordered the release on bail of a defendant or a detainee, both the Commissioner of Police and the Director of Prosecutions, Public Prosecutions, have the power to challenge the decision before the Supreme Court. That shall no longer be the case. The bill provides that the power to challenge such decision before the Supreme Court shall henceforth rest solely with the Director of Public Prosecutions and nothing to do with the Commissioner of Police. The amendment bill, therefore, will give greater clarity and unambiguity to the respective powers of the CP and the DPP in relation to bail. This amendment, Madam Speaker, to the Bail Act makes it clear what are the powers of the CP and what are the powers of the DPP in relation to bail. Thank you, Madam Speaker.
Thank you very much. You will probably be in time, I suppose.
Yes, there is time, but Madam Speaker, thank you very much. I'd like to thank all those who have participated in this debate. And time and again, what we've heard is the importance of democracy. What we've heard is liberty. We've also heard about jail, but all this with the whole idea that what we have to do away with, and what, in God's name, thank God we did away with them, and how we are now fighting, struggling together and working together as one country, as one people, in order to restore democracy. Let me also, at this juncture, state the following. It is quite interesting how things change in life, and so fast. Only a few years back, I recall, I was myself, since I'm a barrister by profession, I was involved in a case that has been dealt with, so there's no issue of conflict. And I recall that when I was in court, and I'm sure that the then accused would not mind me saying his name today, but it was Bruno Lorette. I remember when I was in court appearing for him to move for bail, all those sections of the law that we have seen how it has been abused of by the then Commissioner of Police all came up. We won bail, in spite of it being a very difficult task. We won bail. But I recall how in those days there was fake democracy, as an honourable member said. Why do I say that? Because when we won bail, the Commissioner of Police issued a communiqué. That was on the 28th of February 2023. And for all to remember, in that communiqué, the Commissioner of Police said the following, I quote, "The decision of the office of the DPP therefore creates an evil precedent," unquote. That evil precedent that the then Commissioner of Police was referring to was the decision of the office of the DPP after having looked at the ruling of the learned magistrate, decided that he will not object to the release. The Commissioner of Police, for the first time in history, for the first time ever since we have our constitution, our independence, he went as far as to say it was an evil precedent. And to add insult to injury, what did the then Prime Minister do? He made a declaration and he said, "Mafia fin infiltré man institution sa pays là." The GIS published the communique of the Commissioner of Police. The GIS does not publish the communique of the Commissioner of Police. The GIS publishes the work of government, the executive. So there had disappeared this respect one must have for institutions, where the Commissioner of Police had himself felt that he was part of the government ministers. He was a little department in the office of the Prime Minister, whereby whatever he said had to be aligned with what the Prime Minister wanted and had to be published by the GIS. Those days are over. And this is what, when the Honourable Govind said, "Let Mauritius be Mauritius again," how right she is. And this is what we're standing up to fight for. So this is a very important day for democracy, and it is a pity. I said it last time when I intervened, I say it again. It is a pity that the leader of the opposition, his position is there in the Constitution, there, his role, his responsibility. It's not only for him to earn his packet at the end of the month, it is for him to be here and to be the voice of the people. But then, not only is not here, they will also not be at the municipal elections. Then again, as I said, things change very rapidly, and how thanks, I'll say that to the Almighty, thank God we are now coming on the right path. So those are my words, Madam Speaker, and I do commend this bill to the House.
Motion must be seconded. Motion must be seconded. Seconded? Who's seconding? Yes, Dr. Boulel. The question is that the Bail Amendment Bill number 3 of 2025 be read a second time. Those in favour say aye. Those against say no. The ayes have it. You're not going to miss iftar.
Public Bills Committee stage. Clause 1, short title. Clause 2, interpretation. Clause 3, section 2 of Principal Act amended. Clause 4, new section 3B inserted in Principal Act. Clause 5, section 4, Principal Act amended. Clause 6, new section 4A inserted in Principal Act.
The question is that clauses 1 to 6 stand part of the bill. Those in favour say aye. Those against say no. The ayes have it.
Title and enacting clause.
The question is that the title and enacting clause stand part of the bill. Those in favour say aye. Those against say no. Aye. The ayes have it. Now I put the question that I do report to the House that the Bail Amendment Bill number 3 of 2025 has passed the committee stage without amendment. Those in favour say aye. Those against say no. Aye. Thank you. I will resume my chair. Honourable members, I have to report to the House that the Bail Amendment Bill number 3 of 2025 has passed the committee stage without amendments.
Public Bills, third reading.
Speaker, I move that the Bail Amendment Bill number 3 of 2025 be read a third time and passed.
Yes, Honourable Attorney-General, Acting Attorney-General. The motion needs to be seconded. Yes? The question is that the Bail Amendment Bill number 320 of 2025 be read the third time and passed. Those in favour say aye. Those against say no. The ayes have it. Honourable Prime Minister.
Yes, Madam Speaker, I beg to move for the adjournment of the House to Tuesday, the 8th of April at 11:30 a.m.
Okay. The question is that the House be adjourned to Tuesday, the 8th of April at 11:30 a.m. Those in favour say aye. Those against say no. Aye. The ayes have it. The House stands adjourned